But we go. Look for this thing today, my lord.
Today,
Today, my lord, there's a eviction matter.
today not possible. Tomorrow we can try.
Tomorrow.
Similar prayer, my lord.
Tomorrow.
My lord. Not my lord, we are apprehending that any time.
When was the notice served?
Notice was served, my lord, on 29/12. 15 days time had been given. We have submitted the reply, but thereafter no response. Now verbally they are saying that you vacate or we will demolish. That is the issue, my lord.
Tomorrow.
Tomorrow.
Today, my lord.
Today not possible.
My lord.
Problem.
Obliged.
May I please, your lordship, my lord, I beg to mention item number 30 and 31.
30 and 31.
Okay.
Yes.
My lord, I have, my senior has got some difficulties today, so the matter may kindly be adjourned, my lord, and as the other side, they are expressing their urgency, let it be on 28th, my lord.
30 and 31.
Yes, my lord.
31, my lord, I filed an IA, my lord.
Huh?
I filed an IA for vacating the stay order, my lord, and they are enjoying the stay order, my lord. Matter is the urgency, my lord.
28. As agreed to by learned
Deplorable.
parties. On the request of Mr. J. Abidu, counsel for the, you're for the petitioner respondent.
I'm for the, in this 30, I'm for the respondent, and 31, I am for the petitioner.
And appearing for one of the parties has expressed difficulties and sought an adjournment for the day. As agreed to, let the matter be listed on 28th of January.
My lord, interim passed earlier shall continue.
Interim passed order, if any, passed earlier will continue.
Deeply obliged.
Yes.
Wait, please, your lordship. I am praying for listing of this matter for motion tomorrow, my lord. My lord, ERD, IMFL on-shop licenses, my lord, and for renewal of license, certain documents are required. But this time, my lord, they have incorporated another condition. Deeply obliged.
May I please, your lordship? My lord, I am praying for listing that two matters, lordship, tomorrow, lordship.
Why?
Notice issued, lordship, to demolish my house. My case is pending. I filed an IA also Monday, lordship. Otherwise, they will evict me, lordship. In spite of pending my case, lordship, they issued notice to deliver the possession. Otherwise, they will forceful eviction.
Notice is under challenge.
Notice, earlier the notice not been issued. Now they have issued notice, lordship, to remove our structures, lordship. I filed IA, lordship.
Oh, I have been filed.
Lordship.
All right.
Obliged, lordship.
May I please, your lordship? I should like to mention one admission, my lord, in first week of February, my lord. Pleadings are completed, my lord. After 3rd, my lord.
Let it be on 4th of February.
May it please your lordship. Lordship, with concern of the other side, I'd like to mention item number 43 of today's daily list.
43.
Lordship.
Yes.
Lordship, in this case, we have to file our affidavit in opposition, bringing into record certain documents.
You're appearing, Dr. Saraf?
Fine.
Any objections?
Only the, after the filing of the action of position, 2 weeks further time may be granted for filing reply. Thereafter, matter may come.
You want to file your affidavit?
Lordship.
All right. 43 on the request made by Mr. M. Bhuya, counsel for the respondents, seeking liberty to file counter affidavit. Matter stands deferred to be listed after 4 weeks. Petitioner is also permitted to file rejoinder affidavit if so advised to the said affidavit in opposition supposed to be filed by the respondent.
But after 2 weeks after filing of the action of position. Otherwise,
We are giving you 4 weeks.
Lordship.
Matter be listed after 4 weeks.
if they file on the 3rd week last, it's difficult without 4 weeks.
The respondents will positively file their affidavit within 2 weeks.
Lordship.
Yes?
Lordship. 3 weeks, Lordship, if possible. Oh,
2 weeks, 2 weeks.
2 weeks, Lordship.
The
Lordship.
interim order passed early may continue.
Interim order passed audio will continue. We'll have it on 11th.
11th. Lordship.
Yeah, 11th will not be 3 weeks. On 20 February.
20 February. Much obliged, Lordship.
Lordship, I beg to mention item number 34. I'm appearing on behalf of Dr. V.N. Gogol. Notice has been served, but reply has not been received. Any instruction has not been received.
You wait.
May I please, your lordship?
Wait for the matter to be called up.
Please, your Lordship. Lordship, I beg to mention for listing of the WBC matter, Lordship. Lordship, the matter pertains to eviction matter. Can it be listed on your Lordship tomorrow, your Lordship?
New matter.
New matter, your Lordship.
When did you file it?
Yesterday, your Lordship.
Yesterday. Challenging what?
A notice, eviction notice, your Lordship.
When was the notice served?
12th of January, your Lordship. 10 days time were given, your Lordship.
All right, tomorrow.
All right, Lordship.
Wait, please, your Lordship. Lordship, I beg to mention for listing of a matter for withdrawal, Lordship.
Tomorrow?
Oblige, your Lordship.
But please, your Lordship, with the consent of the other side, I beg to mention item number 33 of the daily list, your Lordship. We need 2 weeks' time to file an affidavit, your Lordship, in this matter.
You wait for the matter to be called up.
Lordship, prayer for listing fresh matter, my lord.
Fresh matter.
Yes, my lord.
When was it filed?
18/12/2025, my lord.
Must be because of some defects, it was not listed.
Yes, my lord.
28th
Oblige, my lord.
January, subject to clearance of defects.
May I please, Lordship,
Yeah.
paying for listing of one urgent matter tomorrow, Lordship. This
Huh?
happen in this, an
Huh?
urgent matter tomorrow, writ petition, Lordship.
What is the urgency?
Urgency is that, Lordship, this, in one particular land, the petitioner is in possession. In this particular land, Lordship, there is a civil suit pending. But what has happened, the police has given communication to the petitioner that they are going to demarcate the land. I have submitted all my injunction petitions, everything I have submitted, but they are intending to demarcate the land and there is every possibility I will be dispossessed from the land, Lordship. So at this point of time, some protection is required, Lordship. That's why I'm just praying for listing by tomorrow, Lordship.
Can it not wait till next week?
Lordship, they have already done some damage to my boundary wall, Lordship, and that too without any communication. They are saying that some FIR has been lodged or some complaint has been filed, but I have not served with any copy of the complaint, Lordship.
All right.
Tomorrow, Lordship.
I beg to mention on writ petition for listing. Eventual listing.
Listing of what?
Writ petition,
Why?
long pending matter. Long pending matter.
Long pending matter, all right. What is the subject matter?
The matter pertaining land acquisition.
Land acquisition, all right. List.
Kindly fix
On
on
6th of February.
28.
6th February.
Similar matter already fixed on 28.
28.
Yes, Lord.
All right, then 28.
Hello.
May I please, your Lordship? May I be allowed to move an urgent application tomorrow, my lord? I have already filed it yesterday. It is numbered, my lord.
What is the urgency?
Urgency is that, my lord, I am facing a demolition of my house over Patta lands, my lord. At the behest of somebody who wants to, my lord, take over the lands and evict me by force so that they can raise my lord.
But there are appellate forums available before the authority.
There are, but even then, because partially already the house has been demolished, my lord. So
All right, tomorrow.
I'm deplorable.
Wait, please, Lordship. Lordship, I beg to mention one WPC for listing. Lordship, the matter is pertaining to land acquisition. If possible, kindly be fixed on 28th of January. The
30.
similar matters are there.
30. Please,
Lordship, similar matters are there.
let it be. Whatever similar orders are passed, we'll also pass it in your matter on 30. Yes.
May I please, your Lordship, with the consent of the other side, I beg to mention item number 44, Lordship.
Yes.
They have just filed their affidavit in opposition yesterday. So we need some time to go through the same, Lordship.
So what is the matter about? We are making a mention on whose behalf?
Advocate-
Petitioner.
Petitioner.
Who's for the respondent? You wait for the matter to be called up.
Yeah, please, your Lordship. Your Lordship, I beg to mention 2 writ petition for listing, Lordship, in orders column. It will be listed on Lordship 27.
On 4th of February.
Obviously.
Pursuant to last order of this honorable court, my lord, partition of land has been done, my lord, by the circular officer on 19/11/2025.
Mr. J. Sharma, learned counsel for the petitioner, and instruction submits that the petitioner does not wish to press the petition any further. Accordingly, the same stands dismissed. As not pressed, interim orders, if any, stand vacated. Pending ayes, then also dismissed. Mr. J. Hendig appears for.
State
for the state and SPR Monto for the
Very
regulation.
compact. Like. Sure.
May it please your lordship. Lordship, the matter ought to have been listed under admission, lordship, due to an
Yes.
inadvertence, lordship. The matter has come.
Notice in the matter was issued on 5/6, no, sorry,
7/4/25, lordship.
on
7/4/25, lordship.
on 7/4/2025. Therefore, matter has been wrongly listed for motion, list again next week for admission.
The contempt petition, my lord, there is a clear direction from the honorable court to the Silchar municipality executive officer, my lord, that you dispose of the complaint of the petitioners and you file a compliance report with this honorable court. But till today, no, my lord, that is not been disposed of and no compliance report has been submitted. So let notice be issued, my lord, that.
Heard Mr. T.J. Monto, and a senior counsel assisted by Mr. R. Subrahmanyam. The petitioner being aggrieved by the willful disobedience, deliberate and willful disobedience of the directions contained in the order dated so and so, passed in WPC so and so, has filed the contempt petition. Issue notice returnable forward steps by registered post within 2 weeks from today. You want to take Dusty?
Yes, ma'am.
Service by way of Dusty. Service of notice by way of Dusty, routed through the registry of the High Court, has also permitted.
Yep, yep.
List accordingly.
May I please your lordship? Lordship, the matter may be passed over for the time being.
You are appearing on whose behalf?
Dr. B.N. Gogol.
What is the matter about?
Lordship, it's about bank matter.
Perception freeze, account being freezed.
You are appearing.
Marked by way of one complaint in the cyber fraud.
Yeah, you are representing whom?
UCO Bank, your lordship.
And
Dr. B, sorry for Islam.
Sorry, full Islam petitioner.
who are you representing?
Sorry for Islam, the petitioner.
Petitioner. So what do you have to say?
Lordship, senior is in the NCLT court appearing the hearing matter.
That's not a ground for adjournment.
No, Lordship, pass over for the time being.
At the end of the list.
Wait, please, lordship. They are supposed to obtain instruction. Lordship, on our position, we have to obtain.
Any instructions?
Yes, lordship. Order in original was also set through speed post, chocos notice and personal hearing letters. Personal hearing letters, order in original and chocos notice. He has been sent through speed post, lordship. I have the date.
Yeah, I have not understood. You are saying order in original?
Chocos notice and personal hearing letters have been sent through speed post to the petitioner.
When?
Lordship, date is there. I have received the order.
No, is it prior to the order or before?
Before.
Prior or after? When was the order?
Our contention is that we have not received any order or focus. We have received a recovery notice, my lord. After we come to know and we have processed honorable court, my lord.
You have to find out what has happened, whether it was served or not.
Lordship will file our affidavit then.
Mr. R.S. Mishra for the petitioner. Mr. K. Jain appears on behalf of the GST authorities. Preliminary instructions, Mr. Jain submits that order in original, what is the Shoko's notice?
Shoko's notice.
And?
Order in original and personal hearing letters.
And personal hearing letters were also sent to the petitioner prior to the issuance of the order in original. So he has, the counsel for the petitioner, however, submits that the petitioner did not receive any such documents except the recovery notice dated 1/12/2025. Accordingly, this court considers it necessary to issue notice returnable 4 weeks. Since the respondents are represented, notices are waived, extra copies will be furnished, if not already done, within a period of 1 week from today. Respondents may file their affidavit in the meantime. Interim orders passed earlier will continue.
Much obliged.
Yes.
Please, Your Lordship. But here, my lord, so is it under section 74, alleging fraud and suppression of facts, my lord. After ordering original, my lord, the charges were dropped, my lord. The penalties and taxes were
Where?
dropped.
In the
Interest were
instructions?
Lordship, in our contention, section 50 is an independent section, Lordship. When there is a delay in the payment of taxes, section 50 imposes.
I heard counsel for party issue notice returnable 4 weeks. Mr. K. Jain represents Mr. SCKL as SCKL standing counsel of all the and appears on behalf of all the respondents. Therefore, notices are waived. Extra copies, if not already furnished, may be furnished. Matter be listed again after the returnable date. List again on the 25th of February. Till the next date fixed, the respondents will not proceed against the petitioner for recovery of interest by the impugn notice.
Much obliged, Your Lordship. But in this case, Your Lordship has permitted me to file an additional affidavit, my lord. It is in the process of filing. Lordship, I will take up next week, any date, my lord.
Matter be listed next week on the prayer of the counsel for petitioner that the affidavit permitted to be filed is in the process of being filed.
Right.
List accordingly, Mr. B. Chaudhary for the respondents.
Much obliged, Your Lordship.
Yes.
Wait, please, Your Lordship. My lord, on earlier occasion, the government is to file affidavit, my lord.
Yes. Where is Mr. Borpuzari? Any instructions here?
No, Lordship. Issue to notice to question. Notice to question. Notice to question. Question and I. My lord, let the notice be issued, Lordship. In the meantime, we file a.
Heard. Counsel for parties issue notice returnable 4 weeks. Mr. J. Hendick, learned common counsel, accepts notice, appears and accepts notice on behalf of
2, 3, and 4.
respondents 2, 3, and 4. MSPR Monto appears for respondent 1. Since the respondents are duly represented, notices are waived, extra copies will be furnished within a period of 1 week from today. List again after the returnable date.
Lord, there is an interim direction, my lord, that may be contained.
What interim direction?
Interim direction, my lord, no further action will be taken on the land in question.
Where is that?
What I say?
In the order itself. Last line. my lord.
The interim direction issued by the order dated 6/1/2026 at para 12 will continue until further orders.
Returnable, Lordship. 4 weeks.
4 weeks. Yes.
May it please your lordship. Lordship, we have received the instruction yesterday. Kindly please grant us 2 weeks' time to file an affidavit, your lordship.
Mr. K. Meera for the petitioner, MS Bhatt for the Corporation Department. Counsel for the respondent submits their instructions have been received.
Yes, your lordship.
They'd like to bring it on record by way of an affidavit. Issue notice returnable 4 weeks. Since the learned counsel represents respondents 1,
2, 3, 4,
1, 2, 3, 4,
5, and 7.
5 and 7. Notices on behalf of the said respondents are waived. However, extra copies be furnished within a period of 1 week from today. Steps on respondent 6 by registered post, AD, registered post within 1 week from today. List again after the return.
Since the appeal has been dismissed, your lordship, operation of the impaired orders may not be continued.
Operation of
Order dated 12/12/2025.
We'll file an affidavit, your lordship.
Because our petition has not been rejected on merit, your lordship.
No, your. We'll file a reply after that your lordship may decide, your lordship.
question of any interim order will be decided after the respondents file their counter affidavit by the next date. By the next returnable date. 4 weeks or before that returnable date be given. What? No. We'll give you a date after 4 weeks.
Lordship, obliged.
I think 9.
May I tell what? Lordship, in this case, Lordship, the petitioner respondent number 2, your 6th Lordship is an elected government member, Lordship, and petitioner Lordship was the contesting candidate, Lordship. And Lordship, subsequently, petitioner Lordship came to know that Lordship, the respondent is not a qualified Lordship. He has not annexed the declaration, Lordship, at the time of.
We will issue notice to the third counsel for parties for the petitioner. And who's for the respondent?
1, 2, 4, and 5.
Your
1, 2, 4, and 5.
your name?
P. Thapa. P. Thapa.
P. Thapa. MS P. Thapa appears for respondents 1, 2,
4, and 5.
4, and 5. Mr. J. Pandek appears for respondent 3. Therefore, notices on for respondents 1 to 5 are waived as the council represents the said respondents. However, extra copies will be furnished within a period of 1 week from today. Steps on respondent 6 by registered post within 1 week from today. List after the return date.
Let please your lordship. My lord, in last occasion, my lord was given time to apprise your lordship as to why my lord my account number has been switched. And this is
Yes.
the listed below.
796.
796, my lord.
Yes, your lordship. Disputed amount is 796.
And that amount is not there. I have verified, my lord. I have given the statement. In the statement, my lord, that is not reflected.
So what is to be done?
Your lordship, we have only received an instructions from the MHA department of Andhra Pradesh. That is in cyber crime cell.
Third counsel for parties. Mr. M. Sharma, learned standing counsel for the bank, submits that as per the
And my lord,
instructions
the coordinated.
received from respondent 4.
Yes, yes.
Respondent number 4. The account has been freezed. Account of the petitioner is freezed as an amount of rupees 796.19 has been stated to be credited to the account, to the said account, against which there is a cyber complaint received or filed in the state of Andhra Pradesh. And as a consequence thereof, the entire account has been freezed. So, counsel for the petitioner on the other end submits that this account is used for meeting his business as well as family expenses. And his entire
And page number 20, my lord, statement, my lord. No amount.
entire amount credited in the deposited in the account has been freezed, causing hardship in running his business as well as meeting his personal requirements. So, counsel for the petitioner has enclosed copy of the bank statement of the said account to submit that no such amount is shown to be credited to the account of the writ petitioner. Therefore, the steps taken by the bank authorities to freeze the account is on non-existent grounds. There are Mr. M. Sharma, Planning Council, UCO Bank, submits that the account has been freezed only on the instructions received from the respondent number 4. Accordingly, this court directs the respondent authorities that because upon hearing the counsel for parties and upon perusal of the papers available in the writ petition, this court directs the respondent bank to allow the petitioner use of his bank account however, ensuring that what is the minimum deposit required?
My lordship, it is 15,000, I think.
15,000.
10 or 15,000.
Minimum
deposit.
Uses by maintaining the minimum balance required to be maintained as per the terms and conditions issued by the bank to the customer at the time of opening the bank account. So, in the event, the minimum balance, in the event there is a shortfall in the minimum balance, the bank authorities will be permitted to take all necessary steps to ensure that the minimum balance is maintained in the said account. Stop. Meanwhile, let notice issue returnable 4 weeks. Mr. This is IDFC Bank.
IDFC, not UCO Bank.
Okay, sorry, not UCO Bank.
I would tell your lordship at the end of the order. Because UCO Bank has been
IDFC. IDFC First Bank. Issue notice. Mr. Sharma accepts notice on behalf of 1, 2.
And
any CGC? Yes, Mr. Roy appears on behalf of respondent 3, as also respondent 4.
Lordship.
Let the respondents complete their instructions. Extra copies be furnished to the respective counsel appearing for the respondents. And the instructions, if any, be placed by way of an affidavit within 4 weeks from today. Placed accordingly.
Yeah, please.
Yes.
Petition of consignment of Erecanats were seized and subsequently destroyed without giving any reasonable opportunity to the petitioner. This is for compensation, my lord. Notice may go at this time. This is for compensation, my lord. Notice may go.
Compensation, go to the appropriate court. Why are you coming to the writ court? Are we here sitting to give you compensation? It's a matter of evidence.
My lord, in some similar matters, notice has already been issued.
No, no,
In the
notice
same
issue
sense
is a different issue.
My lord.
Your prayer is for compensation. You have come to the court asking for compensation. How will the court assess the damages?
My lord. The notice may go. At this
There is a provision for compensation under the
Correct.
Customs Act.
My lord, from the same Caesar list, notice has been issued in different letters from this court.
Give us the numbers.
I'll give it to you. The list
But
of
we are not
matters.
inclined to issue notice like this. You show us a copy of the order.
My lord. I'll just.
You give the numbers, we'll take it up after a while. Please show us the numbers. Yes.
My lord, in this matter, my lord, on the other day, Lordship was asked to direct, my lord, the.
My lord, his name was not shown in the corpus.
Whose name?
Rajiv
Purpujari.
Borpujari.
His name is not being reflected.
His name
The
is
name is not shown. What can be done? We have already recorded.
recorded.
He appeared last time.
He appeared,
Ah.
but today, Lordship, he missed, that was, he missed the matter, Lordship.
Order was not uploaded.
But
Then the order reflects the date on which date the matter is to be listed. You can't settle all responsibilities on the registry. When we give a date, you should note it down.
understand, my lord. Next week, my lord, I need it.
May I pray, my lord, notice may be issued, my lord?
Let him come and tell us what is the issue here.
Issue is that, my lord, the lands had been allotted to the.
Now that
cooperative
we have
society.
recorded.
Yes, my lord.
Now let us find out what, he said he will obtain required
Yes,
instructions.
yes, my lord.
So
Let it
list
come
this
up
matter
after-
again on on 6th of February.
Can it be on 9th or 10th, my lord?
It can be on 9th or 11th.
Let it be on 11th.
11th. 11th February. Enabling the respondent council to complete their instructions.
A name may be.
Registry to revenue, Lordship.
Who's representing the revenue?
Arbor purpose.
My lord,
Today, who are you representing? Then why are you insisting on the names being reflected?
Like, standing council revenue,
Why is it necessary?
because
When we have reflected in the order, why are you insisting on the names being reflected in the cause list? They will try to do it.
my lord, if in the list is not mentioned.
Actually, my lord,
Means that.
Number of cases are
Yes,
very
it's our
huge,
list.
number of councils are very low, so they lose track.
It's not many years since I was on that other side.
I understand, my lord.
So I also
On
recollect.
on a lighter vein, my lord.
Huh? There was a system called pocket calendar,
That.
date wise.
now it has gone.
It's not there now, I suppose.
It's not there, my lord. It
It
has
has
been
become
replaced by-
digital.
No, my lord, it has been replaced by that events, my
Control
lord,
app.
that in that mobile, my lord.
Events.
Events, you can, my lord, record the events there and see it on some.
All right. Matter be listed on 11th of February.
11th of
Names of
February.
all standing councils, including revenue, be reflected in the cause list by the registry. Have you taken steps? No.
Yes, my lord. Yes.
Anyone for respondent 4?
Respondent 4, my lord, I have not taken steps because that's a private respondent, my lord, until and unless notice goes.
Although notice is not issued, petitioner will, you serve a copy on the respondent 4.
Lordship will give a direction, otherwise, my lord, the registry will not accept it, my lord.
All right, we'll do it on the next date.
My lord.
List on 11.
My lord, the interim order passed earlier will continue.
Interim orders, if any, passed earlier will continue.
I am diplomat.
Yes.
Right, my lord, item 13, my lord, we need, my lord, some time to file additional FTP.
We close this. You file a fresh petition. You file a fresh petition.
Now, being, my lord, subsequent some development is occurred, we have to bring on record.
All right, Mr. M.U. Mandal, counsel for the petitioner, prays for 2 weeks' time to file an additional affidavit. Prayer made is allowed, list taken after 2 weeks. Mr. S.S. Roy for
3 and 4.
respondents 3 and 4, MS P.R. Monto for 2. Mr. Hendik? All right. After 2 weeks.
Obligation.
Yes.
So, influence. Case number 47, your lordship.
47.
It's a settlement matter, your lordship.
Ah.
Actually, 1 bigger, total, you had around 1 bigger. One bigger, 4 kata, 5 lessers. And out of that, I received more than 90% already, settled actually. But 2 lessers were given to the private respondent. Now the fact was, it was concerning the disposal of a representation. 20 years ago, your lordship, so litigations had been filed accordingly to dispose of the. Finally, this honorable court, in its pristine order, passed an order to dispose of the river. So while disposing of the litigation, in that representative, we had a prayer that somebody, the private respondent had intruded in our land, which was in my possession, right? So that one has not been made. So a humble prayer before your lordship that by looking into this one.
You have added them as parties.
Yes, a private respondent is there.
We can issue notice today, that's all.
Yes, sir.
Lordship heard Mr. Austin Nursery, Leonard Counsel for the petitioner, Mr. S.S. Roy.
1, 4 and
Government
4,
advocate.
5 and 6.
Respondents 1,
4, 5 and 6.
4, 5 and 6.
2 and 3, man.
MSPR Monto for respondent 2 and 3. Since the respective counsel represents respondents 1, 2, 3, 4, 5. Notices are waived, extra copies be furnished within the period of 1 week from today. Steps on respondents 6, 7, 8 by registered post within 1 week from today. You want to take Dusty also?
No, yeah, I'll go for regular.
List again after the returnable date.
15.
Right?
Highly obliging.
Right, please, Robert.
Yes.
Well, the issue involved in this particular matter is on a very narrow campus manner. The respondent authority are trying to construct a road over my plot of land, which was originally owned by my father and which is subsequent to his death has devolved upon me, my lord. So I pray that only that, my lord, the respondent authority may procure instruction as regard to whether they are planning to construct any road over my plot of land, my lord. If they are not, my lord, the end of the matter, my lord. If they are, my lord, then it has to, my lord, it has to be properly acquired, my lord.
What property?
Well, it's a landed property. It's a landed property. I have a house over it, my lord. I have my house,
Land.
my lord. It's a patta land, my lord.
Okay, then agricultural. No,
Agricultural, my lord.
agricultural land.
There's a house also, my lord, and there is a fishery also over that. particular lot.
So why are you apprehending that respondents are?
They are measuring the land, my lord. In fact, they have started digging the land also, my lord. Without making
Which respondent?
respondent PWD, my lord.
PWD. You should go and complain before the.
I have, my lord, I have approached. That is the reason why I'm compelled to approach this honorable court.
What has happened?
My lord, they are not providing. In fact, I have inquired before the person, my lord, who have approached my lord land. They told me that they have been constructing the land under a scheme, my lord.
Not yet.
Pradhan Mantri Gramin Sadak Yojana, my lord, scheme. They have a proposal to construct that.
When was the proposal initiated?
My lord, I do not have any, my lord, knowledge about that.
When did you approach the circle officer?
My lord, in fact, there is an inquiry report by the circle officer also. If I may take my lord to page number 91, my lord. My lord, has it? Only the last 3 lines, my lord. At the time of verification, it is found that there is no path route in the middle or side of dug in the trace map in regard to CETA copy and the trace map enclosed. They have submitted this report also. But despite, I have also enclosed this report. I have submitted this report before the authority concerned. But despite that, my lord, they are trying to construct, my lord. That is my difficulty.
Yes, madam.
Work not yet started, lordship. Not yet started.
No, but whether.
I will take instruction, lordship, whether they will construct or not.
No, but if they have to construct in the land, then there is a proper procedure.
Yes.
If the land is not government land.
Yes, yes. Work not yet started.
Let them procure instruction, my lord. It may be fixed after. I pray that it may be fixed after a week, my lord.
How much time would you require?
10 days time, lord.
10 days.
10 days.
Heard counsel for parties. MS S. Sharma, Learned Standing Counsel PWD will obtain.
1, 2, and 3.
Huh?
1, 2, and 3.
1, 2, and 3 will obtain instruction as to whether the department is contemplating to construct a road over a plot of land covered by DAG number 79 of Patian 45 to number 452 and new DAG number 78 and 94 of Patta number 411 under Polgona Igara Sati Moza. Moza Rothgram, Part 3. The district of Karimganj.
It would be Sri Bhumi now, my lord.
Sri Bhumi.
Presently known as Sri Bhumi, district of Sri Bhumi. Accordingly, let these instructions be placed before the court within 2 weeks. I'll list this matter again on 11th February.
Lordship.
Till then, my lord, they should not make any construction over my
No,
land.
no, lordship. Work not yet
Without
started.
following the due process.
No, no,
of law.
lordship.
Only that, my lord, that much.
No,
Without following the due process of law, my lord.
No, lordship.
Without
Not yet
having any
started.
materials, what interim order do you want?
But if they are, if they construct in the meantime,
If they construct, then
you create difficult.
you are entitled to compensation or whatever.
Lordship.
No, without.
I'll play.
My only apprehension is that, my lord, they are.
Your
constructing-
apprehension is.
That is without any information or intimation to me, my lord.
Do you have a problem with the land or you have a problem of the land being used without paying money?
My lord, I have no problem the land being used, my lord. On my only.
Your only grievance is money.
My lord, it has to be yes to an
Money.
extent, yes, my lord.
So
Yes.
whether they construct today or they construct after 2
They
weeks.
can very well acquire, my lord.
Right.
They can
so
acquire.
your grievance is only with regard to money.
Yes, ma'am.
We are here to ensure that you'll get your money.
My lord,
Yes.
my lord.
So what interim orders do you, why do you want to stop the work?
Then I do not have any difficulty.
Yes.
My lord.
Oblige.
I'm obliged.
May please, Your Lordship. Lordship, in this case, the petitioner of the government servant, Lordship, service order, the Khalasi, Lordship. And he was the, Lordship, grantor.
You
one
are the
Azahara.
guarantor. You are the guarantor.
Yes, Lordship.
You have to pay. That is how the law operates.
Lordship, it is what happened, Lordship, at that time, Lordship, when the Azhar Ali get loan, Lordship, the mortgage was, Lordship, available in, Lordship, records, Lordship.
We can't help you. You are the guarantor. You had given an assurance that in case he defaults, he'll make the payment. Then what can be done now? You file your application before the appropriate authority.
And
DRT.
Lordship, I filed the Lordship, this application, Lordship, is Lordship 40.
Huh?
1/4.
1/4.
1.
Yes. No, not before the manager.
Chief Manager, Lordship, State Bank of India, Gwalpara.
No, that can't be helped. We can't issue any orders. There are other provisions on law that your remedy lies elsewhere, not before a report. You think over it, come back next week.
Obliged.
Matter be listed after 1 week with the request made by the council.
Obliged.
Matter মাটি দিব না, ready করা তো। Yes.
Yes. My limited period, Lordship, kindly see at page 45. Now, they have filed application under section 64 of the Act, my lord.
Who has filed?
Praying for, my lord, the petitioners. Praying for, my lord, enhancement of the, my lord, compensation. But the district commissioner is not, my lord, taking any steps. He has to send the, my lord, matters to the, my lord, learned district judge as per the provision of the Act. That is not, my lord, done.
Right to fair compensation. Transparency.
Section 64, my lord, proviso, provided that collector shall within a period of 30 days from the date of receipt of the application make a reference to the approved authority. Provided further that what the collector is fails to make such reference within the period of so and so, the applicant may apply to the authority as the case may be, requesting it to the collector to make a reference within a period of 30 days.
You have to get your instructions.
Lordship, kindly see the page 41. And it says, this is the speaking order pass.
On the basis of the said application.
Lord, my lord, that earlier, my lord, they have been approached before this court. Lord, then this order was passed, the speaking order was passed on. Getting that. And my lord, that in the middle portion, Lordship, may kindly see. Since the partnership did along with the relevant documents submitted by the one by so and so. Since another partnership did and the relevant document are submitted by the Ibrahim, that is our petitioner, Lord. It is pertinent to mention herein that both the parties are mutually contributed the amounting rupees so and so at the time of establishment of the break clean in the intimated by them. Subsequently, Group B are the, my lord, that the petitioners. They have been given, my lord, that a zero compensation of 41 lakhs. Below, Lordship, kindly see the
Group B.
Group B. They're all the petitioners, their name has been reflected in that Group B, Lordship. They have given that 41 lakhs. And Lordship, kindly see the second part, the subsequently Group B are invested more money for development of the said brick lane
as intimated them by during the hearing. However, both the parties are failed to produce any substantial or the valid documents about their share during the time of hearing, lordships. So accordingly, what the documents is available before the concerned authority, they have calculated the zirat, and it has been given 41 lakhs 56,658 rupees.
So the amount was divided.
Amount was divided. Those who are the person who has the share lordships, they have been divided lordship. Who has contributed for
So you are happy by
development
this
of
order?
Yes, we have challenged this order. Page 41.
All right. All right, I heard Mr. M.A. Mahmood, the counsel for the and Mr. J. Hendik appearing for the
respondent 5 to 7 or 2 to 5 lots.
2
to 5.
2 to 5. And MSPR Monto for respondent number 1. Let notice issue returning in 4 weeks. Steps on the private respondents by registered post within 2 weeks from today.
Private respondent lot of 6 to 27.
We have to take steps on that.
Money.
List accordingly.
Lots. Obliged.
I have been given 2 orders. And similarly, few other matters also pending, my lord, from the same seizure list.
Lordship, here I have some submission. The seized records have already been confiscated by Lordship page.
They're asking for compensation.
How they can, Lordship, they have similarly they have filed appeal before the appellate tribunal also.
Seeking compensation.
No, Lordship, challenging the order of confiscation. Lordship, I come to page 3.
You have confiscated and you have destroyed.
Yes, Lordship.
Then
Without intimating.
how will the compensation be decided?
Lordship, I come to page
Because-
321 for my satisfaction.
My lord, because initially, my lord, the issue is bigger than my lord. Initially, the Arakan Acts were seized by Assam police. Then we approached this honorable court. Honorable court directed that Assam police is not the proper authority because this involves custom, my lord. Then after direction of this honorable court, the Arakan Acts were handed over to the custom department from Assam police. Thereafter, without till then, my lord, the custom department was not issuing any notice or not giving any response to our representations, my lord. Thereafter, suddenly they have destroyed our Arakan Acts from the same seizure list. 27 trucks they have destroyed, my lord, without giving any opportunity, my lord. So several writ petition we have filed and notice was issued, my lord. This is one of them.
What has happened to these writ petitions?
My lord, notice has been issued. Some
In the other
they
cases,
have-
Lordship, the facts of that case are different, Lordship.
No, my
Here,
lord.
Lordship, may
The
please
same-
to see.
Same seizure list. my
Lordship, may please to come to page 240.
Lord, may I see the seizure list? The same-
240, Lordship. Notice was issued to the petitioner. He replied
2-4.
240. Is a order dated 31st of March 2022. The Lordship 321. Paragraph 30. I ordered absolute confiscation of 24,500 kgs of processed dried Arakan nuts. Valued rupees 68 lakhs 60,000 so and so. And penalty was also imposed. Lordship, I have seen that they file appeal before the CSET also, Lordship.
Well, that is different, my lord.
That is page 216.
Oh, but compensation, how to assess the damages?
Because we are challenging the seizure and
So that is pending before the tribunal.
my lord, because the issue is pending before this honorable court. More than 10 writ petition.
You have given us only 2.
My lord,
And from what
My
I
lord,
could see from this order,
my lord.
the allegation is that this is also compensation.
My lord, some more than 10, they have some writ petition, they have already filed affidavit and some. they have-
We'll have these matters listed next week along with this. We'll see that.
Lordship.
Let this matter be listed after In the first week of February. Say on 6th of February.
Fine.
Along with WPC 4002 of 2021 and 3970 of 2021. We'll consider issuing notice or other orders on the next date fixed.
Okay.
Mr. SCKL for the respondents.
I'm for respondent number 1 on behalf of Mr. S.K. Mehdi.
Mr.
KK Mehdi.
KK Mehdi for
Respondent number 1.
respondent 1.
Wait, listen. This is exactly similar to item number 17, my lord. My lord, the 64 application, my lord, page 33. Submitted before the district commissioner, my lord, but the district commissioner has not taken any action, my lord. And in this case, my lord, no private respondent is there, my lord. Just 33.
Mr. Andy, get an instruction here.
Lordship, I have open instruction.
Let him obtain instruction.
My lord.
Heard Mr. M. Hussain, learned counsel for petitioner, Mr. J. Andik, appearing for respondents number
225.
225, and we are on top for respondent number 1. The grievance of the petitioner is that their complaint before the district commissioner comes district collector Dhubri, seeking enhancement of the award of compensation for acquisition of land. It has not been.
My lord. One thing, my lord, in this case, my lord, not in respect of land, my lord, in respect of
only
my
Zirat.
lord, Zirat, my lord.
Enhanced compensation sought for enhanced Zirat compensation has been sought for, and which application has not been considered by the respondents authority, namely the district commissioner Dhubri. Mr. Hendrick will obtain required instructions in the matter. List again after 2 weeks. Although notices are not issued, extra copies be furnished within a period of 1 week from today. List this matter again on 11th of February.
11.
Yes.
Your lordship, matter relates to cancellation of GST registration, your lordship. The coordinate number of orders have been passed by coordinate bench.
When was it cancelled?
It was cancelled in 2021. It's true. But my lord, the other coordinate benches has decided, my lord, because ultimately they will get revenue, my lord.
No, but you are not in business for 5 years now.
My lord, now we want to, in fact,
So go
the
for
business was
fresh-
given
fresh.
because of my lord, chartered accountant and all, my lord, it was done, delayed, my lord. That
Huh?
decision, because of chartered, it was handled by my lord, chartered accountant, my lord. Miscommunication from that side, your lordship. Now we have to resume that business, your lordship. We will pay, my lord, whatever the dues, we will pay.
Yes.
Lordship will seek instruction in this matter.
What instructions?
Similar orders.
Your
my lord,
instructions
page
would have been
46
there with you already.
Page 36, my lord, similar orders. I have managed 4 or 5 orders, my lord. Where also my 2022, 21, my lord, orders have been passed, cancellation, my lord.
All right. You get your instructions. We'll keep it on 28th. 28th January. Get your instructions. You are representing whom?
Respondent 2 to 4.
Respondent?
2 to 4.
Who is 2 to 4?
The principal commissioner of central
TGST.
TGST.
You get your instructions by 28th of January. Whether this matter can be disposed of in terms of the orders which are enclosed in the writ petition. List again on 24th. Serve extra copies. 28th, huh? 24th following 28th. Yes.
Petitioner is a registered NGO, your lordship. Petitioner is a registered NGO, your lordship.
Petitioner?
registered NGO, Your Lordship. Applied for granting aid for a scheme, Your Lordship, under DDRS, Deen Dayal Rehabilitation Scheme, Your Lordship. Accordingly, Your Lordship, district level committee, Your Lordship, recommended for sanctioning of the scheme to the director level, Your Lordship. Thereafter, Your Lordship, granting aid committee has also sanctioned petitioners.
Yes.
Lordship, next let me be given for instruction.
Lordship, kindly peruse last page, Your Lordship. Page 28, Your Lordship. Petitioner has checked the online status of the scheme, Your Lordship, and it is shown that pending with state secretariat. Your Lordship. Pending with state secretariat. Last page, Your Lordship. Page 28. Although granted aid committee has recommended the scheme for sanction, Your Lordship. Annexure 6 is the recommendation, Your Lordship. Annexure 6, page 26 is the recommendation by the grant aid committee, Your Lordship.
You are representing which department?
And for social justice. Social justice.
Social justice. Please get your instructions here.
Yes, Your Lordship.
Heard counsel for parties. The counsel representing the Department of Social Justice will obtain instructions with regard to the claims of the writ petitioner regarding release of grants in aid, which the writ petitioner submits has not been released as per the procedure, and the matter is shown to be pending with the state secretariat as per the information available in the web portal. The learned standing counsel, social justice, will obtain instructions and place it before the court within the next 2 weeks. You are appearing for?
Respondent number 1.
MS.
Jay Sharma. Jay Sharma.
Jay Sharma appears for respondent number 1. Although notices are not issued at this stage, extra copies be furnished.
Yes, sir.
Can you do it within the course of the day?
Yes, sir.
Will be served within the course of the day. Let the matter be listed again on 18th of February.
Oblige you.
Yes.
But,
Go on, wait.
petitioner's company office has been sealed by notice dated 12/8/2024 and followed by another speaking order dated 28/8/2024 imposing huge penalty. And by departmental appeal on order dated 5/8/2025, both the orders have been set aside. Despite that, the property did not pen till it.
By whom?
Lordship, you will find it page now 42. The member appeal has interfered, my lord.
42.
42.
Ah.
I need to get instruction, my lord. What is the
Heard. The petitioner is aggrieved that in spite of the order passed by the appellate authority of the GMC, by the order dated 5/8. The property which was sealed, appellate authority by the order dated 5/8/2025, interfering with the order passed by the subordinate authority, whereby the property of the writ petitioner was sealed, the property has not yet been permitted, property has not yet been de-sealed by the GMC authorities. Being agreed, he has filed the present writ petition. Mr. S. Bora, standing counsel GMC, will obtain instructions in regard to this matter Extra copies, can you serve within the course of the day?
Yes, ma'am.
Extra copies be served within the course of the day. List this matter again on
First week of February.
No, my lord, no, my lord.
11,
2 years, not.
11 February,
But I can do 11 February. I can.
or you want an earlier date?
Earlier date, my lord.
He wants an earlier date, my lord. Lord,
Six.
16 of first week of February, my lord.
6th of February,
6th of February.
6th of February.
Okay.
Yes, madam.
Lordship, I'm a victim of an online fraud which was committed using my credit cards in the Flipkart online portal. I lodged immediately when it came to my notice that this thing had happened. I was sent two OTPs by Flipkart, which I did not respond to. And then immediately within 15 minutes, I found that the delivery was done to someone in Nasik. 2 iPhones and 1 Samsung phone.
Using your card.
Using my card via the Flipkart has 15 minutes delivery system, super fast. And so immediately I complained to Flipkart, I complained to the banks. One was a SBI credit card and one was a ICICI credit card. I complained to the bank that I have not done this to look into the matter. I also filed a cyber complaint before the cyber police in Guwahati. A case was registered. Subsequently, Lordship, it has come to the notice of the investigating officer here that a similar incident occurred in Nasik and the same person in Pune and the same person, Danish, was involved. So he prayed for transferring this case to Nasik and it has been transferred. In the meantime, I also made a complaint before all this, Lordship, I've done within time prescribed by the bank and the Reserve Bank. And I also filed a complaint before the ombudsman, as the banks were not responding positively. I filed a complaint before the Ombudsman, Reserve Bank of India. And Ombudsman called for reports of the bank. And Lordship will find the reports are at page 1 of the reports at page 66. This is what has been forwarded. Your complaint dated this against SBI, this. Your complaint against the regulated entity, RE, SBI Cards and Payments Limited regarding disputed transaction of 46,015 from your credit card on August 15 and reverse the same was examined. The following has been observed. Lordship will find that A, they say, disputed transactions were performed in secured manner and validated using your SBI credit card, including card expired date and CVC, etc., which are confidential, mandatory, and known only to you unless shared by you knowingly or unknowingly. B, dynamic OTP and SMS alerts were delivered to your registered mobile number and no change in your contact details were detected prior to disputed transaction. According to TMT details shared by the RE, an alert was triggered after the transaction and the IV call was placed on you 6 times, which you did not respond. Charge back was raised by the RE to the merchant on August 16th. From the log, it was observed that the first fraudulent transaction attempt was declined because your domestic transaction limit of 50,000 has been reached. The fraudster then attempted a lower value transaction, which succeeded. You have also shared an invoice indicating that the goods and services were received. Hence, the reverse of transaction is not possible. D, it is noted from your correct correspondence RE dated the 22nd September that you received the suspicious link on your phone, which suggests negligence on your part. You also provide a suspect name and number detail. The RE has clarified that the wishing machine and the name cited this are not linked to the database or any of their vendors. The RE has further stated that under the network rules, they do not have any charge recourse available. This office has shared the RE's reply with you via email number this, to which you responded on this with no material addition. Since the matter appears to
So
be
at
of a
this stage, we can only issue a notice. I
Yes,
think
Lordship, but only problem, I want to notice, and only problem is that my amounts are being deducted. Even though I have there's a zero liability policy of the bank, which is at page 76, Lordship. Annex 20, page 76. At
but
clause 6.
there is a process for deactivation and,
Deactivation has been done,
Huh.
but my credit with the bank remains.
right.
So, but there's at page 78, Lordship will see that's a RBI guideline, zero liability of a customer. A customer's entitled to zero liability shall arise when with the unauthorized transaction occurs in the following events: contributory fraudulent negligence deficiency on the part of the bank. This is not applicable. Third party breach where the deficiency neither lies with the bank nor with the customer but lies elsewhere in the system, and the customer notifies the bank within 3 working days. This I have done. Now this lies with Flipkart. So my only prayer is that no further deductions should be made from my account.
We'll issue a notice only on your interim prayer,
Yes.
but if you
Please
want
do.
a shorter date, then you'll have to ensure service of copies on the respondents.
Yes, Lordship, only till the next date, because now again, end of this month, they'll go make another deduction. They've already deducted 19,000, then 3,000, then one more deduction.
No, the ombudsman has returned a finding that there was no deficiency in service.
No deficiency, but this is a fraudulent, so criminal in nature. So
Right.
they accepted that it's a fraud, that the fraud has been committed. After you've accepted that, I must be given that much protection, because 2 they have already deducted. I'm not asking for refund right now. Only subsequent, no amount may be deducted because it's a salary account. I'm a Jawan. How will that? At least till the next returnable day, no deductions had been made.
No, but there has to be at least a prima facie finding that there was absolutely no lapses on your part, knowingly or unknowingly. Because for a credit card transaction, there are certain inputs that the customer is required to give for the transaction to become valid.
Yes, but
like CVV numbers and some detail.
What is CVC in the Flipkart?
Huh?
That is, there is a system for storing your CVC also. Remember my CVC. That kind of, you tick the box. That is what he has done. And only requirement that I must complain, and I complained. And they accepted that there has been a fraudulent transaction. So my next transaction, there may be no deduction. That's all I want. For till the next day, Lordship. After that, if they show some reason, Lordship may vacate it.
I heard MS M. Hazarika, Senior Counsel, assisted by
You Dwara.
MS U1, Counsel for Petitioner. The petitioner before this court is employed in the Indian Army and is currently posted in the Narangi sub-area. So the petitioner is aggrieved that in spite of complaints being lodged before the bank as well as the appropriate authorities regarding a fraudulent transactions which were effected on his credit card. Do you have the numbers, credit card?
Credit numbers, yes, Lordship, I have. They have the credit card numbers. Para 8, page 9, I have the credit number. SBI credit card name is force. It ends with.
There are two credit cards involved.
Yes, one SBI and one XCI. SBI ends with 7034 and ICI is 0001. ICICI.
Where is that number?
Lordship at
Para 8.
Para 8, page 9.
The petitioner has been issued 2 credit cards, one SBI credit card bearing number so and so in red, huh? And one ICICI credit card bearing number so and so in blue. Both these cards were used by a fraudster unauthorizedly in the Flipkart website for carrying out unauthorized transactions to an amount of
Oh, total is 1,94,000.
total
With 1,94,516.
to an amount of rupees 1,94,516 in total. So petitioner filed complaints and subsequently being aggrieved, he had also approached the banking ombudsman
RBI.
under the RBI.
Yes.
Stop. However, the complaint raised by the petitioners to be rejected on the ground that there was no deficiency in service by the bank. And the fraudulent activity that took place was because of contributory negligence by the petitioner. Stop. Learned Senior Counsel submits that the RBI itself has issued guidelines in respect of limited liability of customers in unauthorized electronic banking transactions by the circular dated 6th of July 2017, whereby that clause 6 of the said circular, there is a zero liability of the customer. In cases of third-party breach, where the deficiency lies neither with the bank nor with the customer, but lies elsewhere in the system. Stop. Learned Senior Counsel therefore submits that this order of the banking ombudsman is contrary to the RBI circular. And in view of the acceptance by the ombudsman that there was a fraudulent activity carried on by misuse of the credit cards, the petitioner is liable to be given the zero liability benefit as per the RBI circular. Stop. Notwithstanding that, the bank authorities have started deducting the amount shown to be credited in respect of the credit cards from the accounts maintained by the petitioner. You have 2 accounts or 1 account?
One in SBI, one in ICICI.
So from both the accounts?
Only from SBI, but ICICI I'm getting calls.
You're getting?
Calls to pay up.
Okay.
Salary account is in SBI.
Yes.
Your Lordship, we do not have any instructions because we have just got an instruction to appear in the matter only on the basis of the cause list. So we do not have the copy also.
Right.
Yes, Your Lordship.
Okay.
Under such circumstances, the Learned Senior Counsel submits that adequate interim protection be granted. And the impugned order of the ombudsman be interfered with, and suitable directions be also issued to the bank, absolving the petitioner from any liability for the fraudulent transactions carried on unauthorized in the credit cards allotted to the petitioner. Stop para. Having heard counsel for parties, issue notice returnable 4 weeks. Mr. M. Sharma, the counsel, represents 3 and 4 SBI.
Only for Your Lordship,
Only
ICICI.
appears for the respondent number 4. Therefore, notices on behalf of respondent 4 are waived. Extra copies be furnished within a period of 3 working days from today. Steps on respondent Anyone for RBI?
No one. Lordship, one standing counsel is there, I think earlier, your Lordship.
Not there.
Not there, not there. I mean,
All right.
I'll take steps by registered post, Lordship.
Steps on respondent 1, 2, 3
And 3 by registered post.
by registered post. Dusty is also permitted, provided it is routed through the registry of the High Court. Stop. Let this matter be listed again. On 25th of February,
Fine.
till the next returnable date, no deductions shall be made on account of the outstanding in respect of the credit card liability from the salary account of the writ petitioner, which is maintained in the SBI. Which branch?
West Bengal. West Bengal. SBI West Bengal.
West Bengal. In the SBI account maintained by the writ petitioner. Stop. You can you serve extra copies to Mr.
Yes,
Sharma?
sir.
Yes. List on 25th.
Please, Lordship. Here I have filed an application for mutation by right of inheritance. Mutation, my lord.
Then
But no effective order has been.
no effective order. Instruction.
What happened is sometimes the person who apply for the mutations online, but the phone number has been, they have to put their phone numbers there. Sometimes they have been use the other phone number. That's why some that information has been goes to that phone number who was registered during the time of the.
Where is your application?
Page number 10, my lord.
The phone number is different. My learned friend, the petitioner's phone number is here. The put in this that affidavit is something is different. So that's why he did not receive any instruction, information regarding that.
The petitioner personally approached the concerned circle officer as well as last Monday, my lord. As per RTPS Act, my lord, the page number, my lord, 10, my lord.
No, but why are you giving two phone numbers?
My lord, personally appeared, my lord.
This particular application you have submitted how? Online?
Online.
Yes, my lord.
Then what is the point in appearing personally?
To process the file, my lord.
Oh, that you have already done online. Things are being made simplified for you.
But after applying, my lord,
Does he still have this phone number?
apply, appeared, my lord. Approach, my lord, to the concerned blood model as well as my lord.
How can they say, my lord, it is the.
Please get your instructions here.
Yes, my lord.
Mr. J. Hendrick will obtain instructions in the matter. Subject to extra copies being furnished within the course of the day. Matter be listed on 20 February.
Lord.
Yes, Mr. Bhaiya.
My lord, may I please as your lordship? My lord, an impugn notice as regards, my lord, eviction is under challenge, my lord. My lord, what has happened, my lord, they have termed that the area, my lord, wherein we are residing falls within a tribal belt and block, my lord, which, my lord, explicitly by way of an affidavit, my lord, filed before this honorable court by the Deputy Commissioner Morigaon, my lord, no mention had been made. And this honorable court, the division bench of this honorable court, my lord, while passed an order, also recorded the areas, my lord, which falls within the tribal belt and block in Morigaon district, my lord. So therefore, my lord, this notice, prima facie, my lord, is not maintainable in our case, my lord. Though, my lord, in that notice, 15 days time slot had been provided, my lord, that within 15 days, you submit your document, whatever with you. To, my lord, for that, my lord, I beg to draw my lordship's attention to the impugn notice, my lord, which is at page 200, my lord.
Yes.
My lord, this is a notice, my lord, a notice for eviction of land within the tribal belt and blocks as per section 165(1), subsection 2(3)(a) and B of the Assam Land and Revenue Regulation 1886 to Sri so and so. Since from the preliminary on-site inquiry, it has been confirmed that as per the chapter 10 of the Assam Land and Revenue Regulation 1886, you have been in illegal occupation of land within the aforesaid tribal belt, and therefore there was violation of section 163 and 164. The Honorable High Court in the paragraph 9 of its order of PIL case number 74/2012 has directed to take measures for eviction from tribal belt. My lord, I am just pausing here for a moment. My lord, this PIL number 74/2012 in fact is no way connected, my lord, with the demolition or the eviction from tribal belt and block. This PIL relates to a rickshaws plying in the Guwahati city, connecting with that. So there, I don't know, in all the notices, this number had been mentioned, So thereafter, therefore, as per the under section 165(1), 2, 3(a) and B, you have been issued notice to submit necessary documents, evidence to support your occupation of land in tribal belt within next 15 days. You will be able to submit evidentiary information supporting occupation of your land in the tribal belt before the office of the revenue circle officer. Otherwise, you were asked to remove houses, shops, crops, fences, etc. existing in the aforesaid lands within 1 month of receipt of this notice. In the subsequent period of time on eviction exercise being carried out by the administration in the aforesaid land as per law, for any damages caused, you yourself will be responsible. My lord, responding to this notice, that 15 days time period, my lord, we did supply, my lord, we did submit our, my lord, replies. My lord, may be pleased to find, my lord, page number 246, my lord.
Need to reply. Yes.
My lord, this is the, my lord, acknowledgement of the replies we did submit before the, my lord, authorities, and a copy of the reply had also been annexed, my lord. My lord, may be pleased to find that copy of the reply, my lord. Page number 234, my lord. In fact, my lord, what has happened, we have also submitted our individual replies, and to that individual replies, my lord, this acknowledgement had been given. My lord, my lord, may be pleased to find the list, my lord, which I have annexed, my lord, acknowledged by the authority.
Now, what is the grievance that you are agreed?
My lord, the grievance we are agreed, my lord, after submission of the reply, my lord, till date, they have not taken any decision, my lord, and on the other hand, they are forcing us that we should remove our properties from the land, but by 29th of this month, my lord, we will be, my lord, demolition exercise will be carried out, my lord. So, my lord, once they have said in the notice, my lord, that we should submit our documents or whatever we have to, my lord, to substantiate our claim that in what manner we are under what authority of law we are residing.
So let them obtain instructions. What steps they have to take.
Yes, my lord.
You get your instructions.
My lord, till that, my lord, no course of action may be taken.
You said by 29.
Lords,
Before
My
that.
lord, my lord, nowadays, my lord,
whether they,
my lord, overnight, my lord, bulldozers are being used, my lord. That is the apprehension we are, my lord, we have, my lord.
We are here to protect you. Need not be worried.
Lordship, my lord,
See, there can't be a blanket protection for everything.
Lordship.
No, my lord, I am not asking, my lord. Only in respect of the petitioners, my lord.
That's right.
My lord.
We can't give you an order
My
against the state to say that no coercive action as per in conflict with law in any subject matter shall ever be taken.
My lord, I am not praying that, my lord, that I cannot pray also, my lord.
We are looking into the matter.
Yes.
We are giving them liberty
My lord,
to find out what
Yes.
steps have they taken. In the meantime, if anything untoward happens, we are here to protect you.
My lord, vacations are also coming. my lord.
Vacations are there for the lawyers.
My lord.
For us,
My lord. My lord.
we don't want to enjoy the vacations.
My lord.
Yes.
Well, Lordship, as part of, my lord, that annexer 6 page sheet 232, my lord, they are seeking, my lord, more time. Whether they have been submitted as part of, my lord, that notice.
You get your instructions.
Lordship.
Heard by Mr. Yamamoto, Commissioner. And mm, have Mr. J. Hendick appearing for respondents.
2 to 4 Lottery.
4. Ms. P.R. Monroe.
1.
1. Petitioners are aggrieved by the impugned notices of eviction dated 3/0/12/2025, whereby the petitioners were sought to be evicted, but were also given liberty to submit supporting documents in support of their claims that they have been their legitimate and bona fide landholders. But pursuant to the said notice, necessary documents have been furnished. However, no final orders have been passed, but the petitioners have been informed or given to understand that they should vacate these premises, failing which by 29th of January, steps will be taken to demolish their living quarters. Mr. Hendick will obtain instructions in these matters. Let the matter be listed on 28th.
27th is another matter.
27, my lord, that in the meantime that there are 5 days holiday.
There's a
Lordship,
holiday.
that- let's say 27 also holiday. Lordship, can it be fixed in?
27, why?
No, my lord, that is state holiday. It is not our holiday.
Oh, 28th?
29, Lordship.
29th is the date.
Demolition day.
So you get instructions, start obtaining the instructions
Lordship,
from today. List on 28th. It is made clear that the counsel for petitioner will ensure service of sufficient extra copies
Yes.
to the counsel for the
Except today,
respondent
Lord.
during the course of the day.
Lord, I will start. Obligation.
25.
Yes.
Whether effect is covered by the reasoning and judgment of this own court, below certain elections, when ITC was disallowed on the basis of the earlier provision of section 16(4) of the act, where there's some time limit was there. Thereafter 16(5) was inserted with retrospective effect, my lord, and the relief was granted that those persons who have submitted the return of 50/21, the demand will be, the ITC will be allowed. Now, on the basis of that, my lord, loss in ITC, a matter earlier came up at page 89, my lord.
Similar order.
Page 87, paragraph 7 and 8 may kindly be. That
87.
87, paragraph 7 and 8.
Yes.
Similar type of, but it is more exhaustive.
7 and 8.
Lordship, paragraph, page 87 and page 88.
The same thing is effectively.
Yes, Lordship.
87, my lord, it may pass. Only order in original is dated 18/3/2024.
All right. So it has to be interfered with
Hello.
and remanded.
18/3/2024.
So remanded back.
Yes,
My lord.
the authority will pass fresh order,
Fresh
set in
orders.
second 16(5). Lord.
Let us note for it. Order in original is
3/2024.
18/3/2024. Huh?
18(4), I think.
Okay, paragraph, page number. 86 or the order is a similar order. Huh? Yes,
Any order dated,
disposed.
18-4 again. 18-4.
18-4. Or
18?
18-4-24.
18-4-24.
Lordship.
It heard Mr. Dr. Ashok Saraf, assisted by Mr. A. Borua.
A.
A.
Kaushik.
Kaushik. And Mr. Ezekiel, hearing for the state GST disposed.
Lots. I'm obliged.
Some order was supposed to be passed.
Yes, ma'am, that has been passed and communicated.
We just got it the other day, I think, on the 19th. This 19th. So I need some time to find out what it said. Some instructions of, only on the 19th. is-
All right.
Maybe in the next week?
When do you want it? Second or fourth?
Fourth, Lordship.
Fourth. Matter be posted again on 4th of February. On the request made on behalf of the petitioners that some instructions are sought for in view of the order passed by the appellate authority in the appeals preferred by the petitioner. So, Mr. I. Chaudhary, Senior Counsel, assisted by Mr. S. Chakraborty, appears for the respondent corporation. List on fourth.
Lordship, in this case, an amount of rupees 2,14,000 was fraudulently transferred from the petitioner's salary account. And on being informed by the petitioner to the branch manager, although the said amount was kept on hold, but till that they have not been referred. They are kept to the petitioner's account.
Anyone for the SBI?
Lordship.
So what is the stage of the FIR's file?
It's pending, Lordship.
Mr. Hendik, can you obtain instructions?
Lordship, urgency is that petitioner's daughter has been pursuing MBBS at Hyderabad. So he has to send money every month for her expenses.
You serve copies on the SBI. You serve copies.
We have to.
We can issue notice, but it will delay the matter.
Justice service maybe depends for this.
Heard counsel for parties issue notice returnable 3 weeks.
What's it? Spot date.
Steps on respondent 1 and 2 by registered post. Custody is also permitted, routed through the registry of the High Court. Mr. J. Hendig appears for respondent
3 and 4.
3 and 4. Therefore, notices on behalf of respondent 3 and 4 are waived, but extra copies will be furnished within 2 working days. Place this matter again or after the returnable date.
That's it. Can you date maybe fix this?
Human delivery returnable 4 weeks.
3 weeks.
3 weeks, 3 weeks, 3 weeks. Twenty-fifth.
25th. It's almost 4 weeks. Almost 4 weeks.
4 weeks.
Can it be on 19th?
20.
20. Oh, bless.
Lord, we have challenged the Lord impugn eviction notice that your Lordship will find at page 17.
It's 17.
Type 2, page 17, 17.
17.
17.
Yes.
And Lordship will find there, my lord, first paragraph, occupying golf cart land at village Koera Pahar, covered dag number 150. Now, my lord, we are not in dag number 150. Lordship kindly
Why are you
see,
agree?
because notice has been served to us,
You are not there in 150.
but we are insistently, my lord, continuously, my lord, threatening by the circle officer to vacate the land. Now, Lordship kindly see page 15, where we are, my lord, staying. Page 15 is the, my lord, type copy. A statement showing the details, particulars in connection with the acquisition of the land through direct purchase by way of negotiated a statement for improvement and upgradation of the road from Jogigupa, so and so, so and so, so. Now, these are the person, my lord. Now, Lordship kindly see page 15B. Page 15B.
Yes.
Lordship kindly see, my lord, first, second, third, fourth column. Here, Lordship will find patta number 38 and dag number 148. And we are the tenant of the, my lord, lady Geeta Rai Sarkar. And accordingly, my lord, being interested person, we have also, my lord, got the compensation from the competent authority. Now, despite that, my lord, they have issued the, my lord, notice under section, my lord, 18(2). Where is it?
Yes, what can be done now? You received on 8/1. Why are you waiting for?
No, my lord, it was served on 17.
Huh?
It was served on
They
17.
have
We have
asked
yesterday.
Lordship, I kindly see that annexure 2, Lordship, in the vernacular, page 18, Lordship. They have asked to submit the documents within 23/1/26. So today is 21. Whether they have been submitted any documents or not, that
We have already submitted on 17. 17, we got the notice. 17, we submitted the application to the circle officer concerned.
let me take
Saying that
inspection
we
on
are
When
not-
did you obtain, where have you stated you have received on?
Yes.
17?
Yes.
Where have you submitted these documents? By which communication?
paragraph 6.
Yes. My lord, paragraph, my lord, 11, Lordship will find.
So how have you submitted? Must be by way of some application.
No, nothing has been enclosed in the along with the petition. Whether they have been submitted any documents or
You have been asked to submit. You
Yes,
said
we
you
have submitted already on 17.
Oh.
But that my lord, enclosure is not available.
Then
But we have been informed, my lord, they have
how have
submitted
they submitted?
on
You get
17.
instructions. You complete your instructions to that effect.
My lord.
How have this been submitted? Everything else, you have some document to suggest.
Yes, yes.
But the receipt of the notice, the submission of this information, how have you done it?
Yes, my lord. I will bring on record the, my lord, communication that is submitted on 17.
Yes. Meanwhile, the state will also obtain instruction.
Yes.
So we post it on.
They have to file an application.
30. List on 30 January.
30. Till then, my lord, status quo.
No.
At least.
First, you have to give these instructions, whether you have.
We will bring on record positively, my lord. But if we are, my lord, evicted on the, my lord, 23rd, what will be the date of this?
23rd, that is not the date of
Evicted on 23rd.
23rd,
23rd, you are asked to
submit a document.
My lord, it has been said, my lord, অন্যথায় অসমভূমি তাৰিখত যিকোনো সময়ত বেদখলকাৰীসকলক উক্ত ভূমিৰ পৰা উচ্ছেদ কৰা হ'ব। Page 18, Lordship kindly see. At any moment, page 18, the vernacular portion. Last paragraph, my lord.
This is given, Lordship, the dag number 150, Lordship. This notice has been given.
If you can get instructions by tomorrow, then it is all right.
Tomorrow.
Hmm?
Tomorrow, let's see.
Or till,
I will,
or 28th.
28.
But then you cannot proceed to evict them.
well, they are past lordship, they have to submit the document before 23 lordships.
Even if they have
Even
not.
then, my lord, they have to submit about some verification, other thing. will
Then
be-
you get your instructions
Lord-
tomorrow.
Lord,
Tomorrow. Let it be tomorrow.
Tomorrow.
You serve extra copies.
No.
Place this matter tomorrow. Enabling Mr. J. Hendik to complete his instructions. Extra copies be furnished forthwith by the counsel for the petitioner.
Obliging.
Copy of this order be marked to the office of the senior government advocate for onward communication. Yes. Notice at this stage. Heard counsel for parties issue notice, returnable 4 weeks. Ms. P. Thapa. Appears for respondent number
3, 4 and 5.
1, 3,
4 and 5.
4 and 5. And who's for state election? Anyone, any standing counsel for state election?
Dubey is there.
Mr. R. Dubey appears for respondent number 2. Steps on respondents 5 to 9 by registered post AD.
So it will be 6 to
By registered post.
9.
Huh?
6, 7, 8, 9.
So who is appearing for 5?
Town Council Secretary also.
5?
Government and
You are appearing? Okay. Then 1, 3, 4 and 5. Huh? And 6 to 9 by registered post within 1 week from today.
what's my interim period will be considered on the next.
Issue notice also on the interim prayer to be considered on the next returnable date list on 20 February.
Okay.
Now, my lord, this is also, my lord, identical issue.
Similar also.
Similar. Tomorrow.
Lord,
Where is the notice?
notice, my lord, page 28.
Lordship, Mala, kindly see this.
Page 28, my lord. And lordship kindly see, page 15 is the, my lord, allotment in favor of the, my lord, petitioner.
Page?
Page 15.
This is not an allotment, Lordship.
This is the resolution, page 15, my lord. First, second, third paragraph, lordship will find resolution number 43. Resolution number 43, resolved to allot a plot of land measuring so and so out of total so and so in favor of the so and so. Now, despite that, my lord, they have issued the notice.
So what resolution is this?
This is
Nothing,
the,
my
my
lord,
lord,
whether it is
resolution, my
the
lord.
SL.
Below lordship will find subdivisional officer sees North Kalmara Obayapuri.
What kind it doesn't contain any head or tail?
That has been, my lord, certified, my lord, given to the, my lord, national. That must only. Let them bring instruction, my lord.
No, Lordship, let me issue notice, Lordship, in regarding that.
Yeah, what kind of an instruction is this? I mean, document.
Document, Lordship, yes.
Part of the document.
Yes, this spot has been, my lord, certified to the petitioners.
How can that be? It's a part of what? Some file, some document issued to them.
That is the,
Where have they got this copy?
it is, my lord, that certified, my lord, by the circle officer, my lord. Let them bring instruction, my lord.
No. They will bring instruction, but this kind of, one piece of document here, there, not sufficient. The general claim is that you are residing there for months together, years together. If it has not been allotted, then there are remedies available for you
Now,
to go and get a declaration. What were you doing?
now since notice has been issued on 8 pond, my lord.
Since when were you there in the land? For how long?
Since 1990.
90.
Yes.
And 1990, there is no allotment in your name.
Now that is the, my lord, allotment, my lord, page 15.
Page 50 is just a resolution.
It's a resolution. Yes, the resolution.
Then pursuant to that, it has to be entered into the record of rights.
Yes. Now,
Since
my,
1990, you have not done anything.
I suggested them to, my lord, file an RTA application to bring on the, my lord, entire, my lord, resolution, so that we can establish our plea before the court, my lord.
Heard learned counsel for parties issue notice returning in 4 weeks. MS PR Bonto for respondent 2, Mr. J. Hendick for respondents 1, 3, and 4.
I'm for 3 and 4 also.
So 3 and 4. Mr. S. S. Roy for respondent 1.
I'm for 2, man.
Huh?
I'm for 2.
Oh,
you recorded.
also 1, 3 and 4.
J. Hendick for 1, 3, and 4. PR Bonto for 2. Petitioner is aggrieved by the impugned notice dated 8/1/2026, putting the petitioners to notice that if they cannot submit necessary documents in support of their claims as holders of the land in question, they are likely to be evicted. Being aggrieved, the petitioner before this court. The counsel for the petitioner, in support of his contention, has referred to a resolution stated to have been adopted by the circle officer. Whereby resolution number 43, an area of land measuring 0 biga, 0.2 quota, and 10 lechas out of a total of 2 bigas, 4 quotas, 15 lechas covered by DAG number 150 within bracket part of village Oreya Pahar has been reserved for in favor of President Secretary Oreya Pahar FCI Masjid Khor. This extract of the said resolution, according to the petitioner, is stated to be certified by the subdivisional officer. The said document, which is enclosed as Annexure 1 and stated to be an extract of the resolution duly certified by the subdivisional officer, does not indicate as to whether the said does not indicate or contain the particulars regarding the file number, issue number, and the office which has taken these resolutions. So, read it as it may. The learned counsel to the petitioner is permitted to bring on record further instructions in support of the claims made. Meanwhile, let notice issue returnable 2 weeks. The respondents will obtain their required instruction. The matter placed again after 2 weeks. For interim, if any, will be considered on the next returnable date, placed on 13th February.
Till then, my lord, status quo. Otherwise, my lord, on 23rd.
On what basis?
On the basis of the, my lord,
this resolution?
No, my lord, the impugned operation as per the impugned notice, my lord.
No, but you claim to be there since 1990.
Yes.
Resolution which does not contain any indication who has taken it, who has submitted this. You want status quo order.
That will, my lord, I will break.
You bring anything if you have.
I will bring on record, my lord. Till then, my lord, status quo at least.
Not till then. First, you bring it on record, satisfy the court, and we will give you interim order.
Yes.
Made please, your lordship. My lord, here is a case, I would ideally submit, my lord, it's not a case where summary procedure should be invoked. In fact, my lord, there was a title suit filed. There is a decree whereby a declaration was made that this is not forest land. Admittedly, my lord, there is a dispute whether it is a forest land or it is a revenue village. And there is a direction of this on the trial court to make a demarcation and survey. And learned single judge did not, agree with that. But eventually, my lord, before the division bench, a submission was made by the government. Now, presently, the survey process is going on. That is how division bench also said you conclude it as early as possible. Now, during the midst of this, my lord, a notice of eviction has been issued. So,
Well, the survey is to be undertaken by whom?
by the, my lord, Revenue Authority, then Director of Land Records, and all these people. And in fact, that process is going on.
And the eviction is by forest.
Forest.
Hmm.
My lord, the notice, into notice is at page number, my lord, 166. First of all, my lord, let me place the findings of the trial court, my lord, decree. If your lordship would kindly come to page number 45. Oh, okay, that's I will. Please come to page 45, last para, my lord. This suit is coming for disposal before so-and-so, in presence of so-and-so, for the plaintiff, and in absence of defendants, it is ordered and decreed that suit is decreed ex parte with cost. It is ordered that lands in the suit are situated within the unsurveyed areas, and lands are not under any reserve area or forest reserve area. Plaintiffs are entitled to get pattas in their name regarding the said suit land. So there was an appeal filed by the state, my lord. This was rejected. So now, my lord, now I think jointly the forest and revenue and director of land records, they are to conduct the survey, my lord, and that process is on. So during the midst of this process, this notice at page 166 has been issued, my lord.
Now, what is the stage of demarcation now?
I think my learned friend has come up with an instruction, my lord, which reveals that it is at an advanced stage.
My lord, if I may take your lordship, my lord, I think this matter can be disposed of, my lord.
So
While-
that 140, sorry, 164. The letter of settlement officer. Now, if your lordship would kindly come to page 164 for a moment, my lord. This is a letter by settlement officer to the deputy commissioner. If your lordship will kindly come to last para. However, the said land was not considered as a non-cadastral village under TS area previously. Therefore, in the light of the judgment minutes of the directors of the then Deputy Commissioner Karimganj, and as per the communication of the Circle Officer Ramkrishna Nagar with Director of Land Records, right later dated so-and-so, Rusanbad village, that is, this is a village in concern, my lord, Kundulkut, Rite Rusan, was surveyed by the team of Assam Survey Party under Mission Bosundara, and pillaring etc. was done during non-cadastral village surveys. Polygon map was also provided by Joint Director of Survey, etc. etc. The matter was also intimated by Circle Officer Ramkrishna Nagar, right later dated so-and-so. In the meantime, Circle Officer Ramkrishna Nagar reported to the District Commissioner, Census Cell, that one NC village, namely Udulkut Siter, this is the village in question, has been created from Batsatila Forest Reserve, right later dated so-and-so. Therefore, thereafter, as per order dated passed by the Honorable Guwahati High Court, the timeline of preliminary survey of Moja Udulkwat so-and-so was prepared with effect from 10/4/23 to 35, which again restarted on from February 2nd, 5th of December 23 to be completed by 25/12/93, right later dated so-and-so. And eventually, last paragraph, my lord. In this connection, it is to be mentioned here that one Kudus Sukur and 45 others filed writ appeal before the Honorable Guwahati High Court against Government of Assam, including Deputy Commissioner Karimganj, and the assistant settlement officer, which was disposed of in presence of the learned counsel for the forest department, also by order dated so, where Honorable Guwahati High Court directed respondent authority to complete the cadastral survey expeditiously as possible, but due to objection raised by the forest department, time and again applying dilatory tactics, survey works could not be completed by the office of the assistant settlement officer Ramakrishna Nagar, which may cause future legal complicacy, including contempt of court. In view of above, I would request you to. So this was the view expressed by the settlement officer. So in any case, the matter is at the stage of Milord survey of the cadastral survey.
Yes, what do you say?
Yes. My lord, may kindly peruse page 45 for a moment. 44, my lord, 44.
44.
That order passed in civil suit, madam. I will see.
No, no, those are in the past.
Yes,
Now,
those are in the past. What has happened, my lord? This civil suit was filed for a declaration.
declaration given but could not be executed.
Because it was not, there was no part of
It could
execution.
not be identified, everything
Yes.
happened.
Then, my lord, the matter, they preferred a writ appeal, writ petition. The Honorable Single just dismissed the writ petition. Then they went to writ appeal. If I may take your lordship to the writ appellate order, my lord. Because I'm not basically contesting because there are certain other developments. I think that will suffice, my lord. Page 155, my lord. Page 155 is the writ appeal. It is basically their submission, my lord. It was not our submission. Anyway, this was the order that this order came to be passed, my lord.
60.
Page 160. Mr. So-and-so, heard so-and-so and so-and-so. By filing this appeal, the appellants have raised grievance against non-conducting of the cadastral survey of the land of the respondent authorities. Today, learned counsel for the appellants has submitted that during the pendency of the appeal, the revenue authority has started the cadastral survey of the concerned land. In that view of the matter, we have the opinion that nothing survives in this writ appeal for further consideration. Accordingly, appeal stands disposed of. Let the cadastral survey, which was initiated by respondent, be completed as per norms as expeditious as possible. So then, my lord, this now they are assailing the notice of eviction that my lord finds at page 166. Firstly, my lord, there were 21 plaintiff in the suit, then 56 writ petitioners. Now they are 159. I've checked, my lord, all of them are not party in the writ appeal. I'm not going to that, my lord. In the meantime, my lord, after issuance of this impugn notice, it is 2nd January 2026, page 166, my lord. Since this survey was found to be not concluded, my lord, this letter has been issued by the DFO to the district commissioner. In fact, yesterday. That also indicates, my lord, that for the time being, we are not evicting, we are going for survey, conclusion of the survey.
When is the survey likely to be completed?
It is already going on, my lord, I suppose. My lord, we'll see, this is dated 20th of January 2026, yesterday, my lord. Address to the DC. Subject, my lord, will see request for conducting joint survey and demarcation to Halia Reserve Forest boundary along with so-and-so, so-and-so. So, my lord, initially they have, my lord, narrated the background facts. When the paragraph number 2, my lord, may see.
Yes.
The Duhalia Reserve Forest was duly constituted and notified in the year 1926, filed government notification number so-and-so, covering an area of 3,478 hectares. The boundaries so notified are final, conclusive, and legally protected under the provisions of the Assam Forest Regulations 1891. In compliance of the directions of the Honorable Guwahati High Court in case number so-and-so, this office undertook assessment of encroachments within Duhalia Reserve Forest, and based on field verification, forest notification records, KML data, and topographical maps, identified areas requiring eviction. Accordingly, eviction notices were issued on 2/1/2026 to unauthorized occupants found within the notified reserve forest boundary in Oilamsera, Pultoli, and so-and-so, and so-and-so. It is respectfully submitted that the areas adjoining Moja, Kalachera, Grant Part 1, and the revenue village so-and-so are clearly recorded as bounded by Duhalia Reserve Forest in Forest Department records, including notified boundary descriptions and KML data, as well as the revenue trace map of Moja so-and-so and so-and-so. The revenue village Dulaichera, Grant Part 2, wherein the western and southern boundary are expressly shown as reserve forest. The legal position regarding the disputed land has already been examined by the Honorable Guwahati High Court in WPC number so-and-so. The petitioner sought directions for conducting cadastral. My lord, these are background facts of the cases. My lord, earlier file, writ petition, then next paragraph, writ appeal. That order, my lord, we have already seen. Next, 4th paragraph, my lord. It is respectfully submitted that the said orders do not dilute or override the statutory finality of a duly notified reserve forest boundary, nor does it permit careless survey inside reserve forest land. During recent inspection and field verification, it has been observed that grave concern, with grave concern that substantial portion of reserve forest land along the disputed boundary have been subjected to severe ecological degradation, including illegal felling and grilling of trees, destruction of dense natural forest and biodiversity, conservation of forest land into monoculture rubber plantations, unauthorized agricultural cultivation, and progressive expansion of encroachment. Such activities constitute serious violation of sections. These are legal provisions they have quoted. Next paragraph is relevant. Last paragraph of this space. At the same time, this office is mindful of the need to resolve boundary-related issues in a lawful, transparent, and amicable manner, so as to avoid future disputes and ensure clarity between the forest and revenue jurisdictions. In this context, a joint survey and ground demarcation strictly limiting to reaffirmation of the notified reserve forest boundary would help reconcile forest notification records with revenue trace maps and prevent further encroachment and environmental damage. Next paragraph, last paragraph, my lord. In view of the above, I respectfully request your good office to kindly initiate and coordinate a joint survey and demarcation of the disputed boundary stretches along Moja, Kalachera, Grand, Part 1 and Revenue Village, so-and-so, in consultation with the Director of Land Records and Survey Assam, and this office so as to conclusively ascertain and protect the sanctity of the notified so-and-so. So precisely, my lord, that is their prayer, my lord. This should be done. That is what we are going. Despite issuance of notice, my lord, this has been proposed now, my lord. So this will be done. Then only, my lord, evictions will be carried out. That will satisfy their claim also, my lord, because they are saying there was no survey done.
There is no indication that you are not proceeding with eviction pending.
Definitely, my lord. If we have issued a notice, then in the meantime, my lord, just at the end of that period, my lord, we
will clarify that in the order.
Exactly, my lord may record my submission, my lord. There it will be, otherwise this letter will be meaningless.
How much time would you require? Who's for the revenue department? How much time for this demarcation? No instruction. This is such an old matter. Your instructions should be available.
Next week,
What next week?
No, but let this process go on, my lord. My submission may be recorded. Unless this is done, my lord, we will not go for it.
No. We can, I am sure the petitioner will not mind if we pass an order that no eviction till the demarcation is complete. Is that the order you want?
No.
No. So you want a time frame.
Yes.
Now for the time frame, we need the instructions from the revenue department. What is the stage? How far will it take? How long is it going to take?
Then my lord may post it on next Tuesday, my lord, I will take instruction.
We'll post it after 1 month.
My lord.
And then we'll see of what is the stage of the demarcation process.
What I say, my lord, what I submit, my lord.
Don't proceed
Let
with the eviction notice.
That is what, in fact, I am submitting, my lord. My lord will post it after a month.
No.
My lord will record this instruction.
We'll record all that.
This instruction, my lord. Also, I record my submission that let this process go on till then. Till it is done, we will not evict.
Right.
Instead of absolutely staying the notice, my lord may record my submission. I'll see to it that nothing is done, no eviction is done, my lord. Because this is the letter of yesterday, my lord. We have issued a notice of eviction, then this has come. So if we don't follow this, my lord, it is basically a redundant document.
We can't stop you from giving an undertaking, but if there is something contrary goes to the undertaking, you are at fault.
Yes, I will see to
Not
it.
the court.
I will see to it. They will not go against me, my lord.
For a month, status quo be maintained, let them go and do the process.
Difficulty is that, my lord, there are so many notices issued.
I'm not using the
This status quo order will, my lord, be used as a, my lord, penalty by others, my lord. So let there be, in this a particular peculiar case, my lord. That's why I'm saying my submission that we will not go for eviction unless this demarcation is done, my lord.
All right.
Deeply avoided.
I heard Mr. K. N. Chaudhary, Land Senior Counsel, assisted by K. Uddin. K. Uddin, Learned Counsel for the petitioners. Mr. P. Goswami, Additional AG, appears for the Forest Department.
My lord.
And MS PR Monto for
7 also, Director Land Record.
Mr. Goswami for respondent number.
My lord, for 1.
You appear for 1.
2.
1, 2.
3, 4,
3,
5.
4, 5.
Yes. Rest, my lord, I think my learned friend. My lord. These are settlement officer, deputy commissioner, and director land. 6 to 10
6 to 10 MS Pierre Mondo. 6 and 7, Mr. S.S. Roy, 8, 9, and 10. The petitioners before this.
Well, let me take notice on behalf of DC, my lord. I can communicate easily, my lord.
All right.
8.
Mr. P. Goswami for respondent number 8 also. Petitioners are aggrieved by the impugned notice dated 2nd of January 2026, whereby they are sought to be evicted from the land under their occupation, purportedly identified to be forest land. Stop being aggrieved. The present writ petition is filed. The dispute or the grievances of the petitioners are long-standing, and in spite of obtaining an ex parte decree in their favor, and which ultimately came to be in their favor, the proper survey, cadastral survey required to be done to identify the land in terms of the declaration issued by the trial court has not been completed. Stop being aggrieved, the writ petition was filed, which came to be dismissed. Subsequently, at the stage when the appeal was filed, the matter came to be closed on the ground that the cadastral survey has been undertaken. Stop. As it stands today, the process of survey is still underway, although not completed. But nevertheless, the Forest Department has issued the impugned notice seeking eviction of the writ petitioners. Stop. Under such circumstances, the Learned Senior Counsel urges before the court that urgent orders are necessary to protect the interests of the writ petitioners. Stop. There are Mr. P. N. Goswami appearing for the additional AG for the Forest Department. On the other end, submits that he has received a communication dated 2001-2026 issued by the Divisional Forest Officer Karimganj Forest within bracket T Division 3 Bhumi 2, the District Commissioner, 3 Bhumi District, requesting for conducting a joint survey and demarcation of the Duhalia Reserve Forest boundary along the Moza Kalachera Grant Part 1 and Revenue Village Dulachera Grant Part 2, and for ascertaining the sanctity of the notified reserve forest. Stop by the
In consultation with Director of Records.
In consultation with
Director of Land Records and Survey Assam.
This a communication was issued in consultation with the Director of Land Records and Survey.
Surveyor of Assam.
Surveyor of Assam. Stop by the said communication, the DFO has requested the District Commissioner, Sri Bhumi, to initiate and coordinate a joint survey and demarcation of the disputed boundary stretches of the Moza Kalachera Grant Part 1 and Revenue Village Daulachera Grant Part 2 in consultation with the Director Land Records and Survey Assam, so that it can be conclusively ascertained and steps be taken to protect the sanctity of the notified Duhalia Reserved Forest. Mr. Goswami, done an additional AG, on instruction submits that although the impugned notice for eviction was issued on 2nd of January 2026, in view of this communication, copy of which has been placed before the court, communication dated 20th January 2026, which has been placed before the court.
Notices will not be acted upon, ma'am.
The impugn notice dated 2nd of January will not be acted upon by the Forest Department.
Till this exercise is done.
Till this exercise of demarcation, joint effort, joint demarcation. Till the exercise of demarcation jointly by the revenue and the forest officers are carried out and completed. So, in view of the submissions made by the learned additional AG on instructions, this court is of the considered view that the matter can be posted after 4 weeks.
My lord.
And since the learned additional AG has submitted in court that the eviction process initiated under the impugn notice dated so and so shall not be carried out in the meantime.
No further entry order.
Records the same and expects the department to the court records the same and no such eviction will be carried out as submitted by the learned AG, additional AG, in terms of the impugn notice. Next reasonable date. Meanwhile, the Forest Department as also the Revenue Department will complete their instructions as to the stage at which the demarcation, at the stage of the demarcation being carried out as permitted.
We may be also permitted to take part, my lord, in the process.
Yes.
The petitioners, if not otherwise prohibited under the procedure prescribed, may also be permitted to take part
In the
in the
demarcation.
same process.
Deeply.
But we have not issued notice.
Let notice go. Let notice go. Let notice go, or my lord may keep this like this only because we have already taken notice.
No, because they will not be able to obtain instructions.
Yes.
Yes.
Yeah.
Let notice go.
Therefore, let notice issue returnable. For
19.
Respondents so and so are represented. And therefore, notices are waived, extra copies be furnished within 4 working days from today. Matter be listed again on
20 or 23rd February.
25th.
24th.
February.
I get some time being a hearing day. 24th or 26th.
All right, 26th.
My lord. Deep level.
26th. We are retaining a copy of your instructions.
Yeah, that maybe
Copy of the instructions furnished before the court by the additional AG is retained in the case recording. List accordingly.
Authorities are at liberty to do this exercise well.
Sorry?
They are at liberty to do this exercise well.
It is made clear that the revenue authorities, there is no restraint by the court in carrying out the joint demarcation
as proposed by the
communication. As proposed by the by
communication dated 21.
By the communication dated so and so by the DFO.
Deep level.
Item 53.
Let me the last. My lord, eviction notice at least 33, madam.
30?
33, my lord, vernacular in 34.
You are in possessions in 1900.
My lord, that is their record, my lord. Actually, not 1900, about 50, 60 years, my lord. That is
50,
wrong.
60
record.
years.
My lord, about 50.
These are what grazing land.
My lord. My lord, it is fast land. And your lordship, one thing your lordship would be pleased to see, I'm referring
We
to
had passed a similar order last week.
page 35, madam.
In one of the matters, we had passed a similar order last week.
Yes, madam. Yes.
Do you have a copy of that order?
Yes, madam, that order is there.
Ah.
Petition. Petition, co-petition, madam.
Order to it. We passed a similar order.
My lord, it is in the same circle, my lord, but this village is different.
Mr. as Roy, you've seen that order?
Lordship.
We passed a similar order.
Lordship.
My lord.
Heard counsel for parties, sir. Same order. Notice dated 2012-2025. The returnable on
It was on 19-1.
not 19, we'll have it on 25th. We'll have it on 25th.
25th of February.
Yes.
Obligation.
Madam, let it be list along with this writ petition, Lordship.
19.
On 25th, Lordship, because it was on 19-1.
No. We know 19-1,
Lordship.
but
yes.
this writ petition, we let some orders may be passed in that writ petition which can cover up.
Lordship.
Or you want both matters on the same day?
Lordship.
All right, 19-1.
19-1 has already.
19-1.
19-1 has.
19-2.
It was
Sorry. 19-1
has already gone.
already gone, sorry.
Let it be on 25th,
25th.
25th too, along with.
Along with WPC so and so.
Obligation.
Wait, please. I purchased a three-story building in Contempt godown in the year 1989. And the building in the godown was constructed in the year 1969 by my vendors. After obtaining construction permission in the year 1968 from Guwahati Development Authority. And thereafter, we are paying the GMC taxes and the same was assessed. Kindly peruse Annexure 1, page number 30. This is a building permission issued by the Guwahati Development Authority in the year 1960.
Page number?
36 and type copy 33. And the same was obtained by my vendor. Thereafter, we are paying the GMC taxes regularly. Kindly peruse page number 38.
What is your prayer now?
My prayer is that they have issued a demolition notice that I have no construction permission.
You have no
construction permission, which is at page 95, Annexure 18. My contention is that I have no permission under the GMC Act, but I have permission under the Guwahati Development Authority. Page number 95, Annexure 18.
95.
Page number 95, Annexure 18, the issuing order. Where you have carried out the following nature of unauthorized construction in the schedule given below without requisite permission from the Guwahati Municipal Corporation. In contempt of the GMC Act and bylaws. The third line, accordingly, no reply has been received against the said notice. I have submitted my reply also, which is at Annexure 17, page 91. I have submitted.
There is an appellate provision, Mr. Bora.
There is an appellate provision, 438 of the GNC.
But is permission under both the authorities necessary?
No, permission, my lord, here, my lord, there is a permission of 1968, where I have seen there is a permission of go down, my lord. There is a permission of go down. Actually, if lordship come to the notice, my lord, my friend had notes on the section 8, page number 88. It is the initial notice, show cause notice of under section 337, 1 and 2. Where the show cause notice to reply within a period of 7 days.
Page number?
88, my lord.
88.
88. This is a show cause notice. And lordship in next page 89, my lord. He says that there is a permission from the GMDA, but he doesn't have the approved plan. And my lord, next page 19, page 90, my lord, 6 additional time. By that time, my lord, on this is dated 21/12/2025, my lord. And thereafter, my lord, he files the reply. That is on next page, my lord, page number 91. It is 31/12/2025. By that time, that 7 days period is over, my lord. Therefore, my lord, and impugn order 95, therefore, there is in paragraph number 3, there is accordingly no reply has been received against the said notice.
Now it has been filed.
It is filed after that particular period of 7 days. That has not been taken into record, that I have to.
My lord,
Why is it not taken into record?
My lord, that may be because it is found beyond the period, my lord.
No, but
it should have been taken into record, but that I have to say, my lord. It should have been,
that
should have been examined, my lord.
You examine the reply. Heard counsel for parties. Petitioner is aggrieved by the impugn notice dated 16/1/2026. By which the GMCA authorities had called upon the petitioner to remove or pull down the unauthorized construction mentioned in the said notice. Stop. The counsel for the petitioner submits that this notice has been issued without considering the reply filed by the petitioner to the notice which was earlier issued. Better. Mr. S. Bora, letter standing counsel, submits that the first notice was on 19/12/2025 in respect of the said construction, where the petitioner was asked to submit his explanation. Within a period of 7 days. Stop. Subsequent thereto, the petitioner sought time. But within 7 days, no reply was filed. Therefore, the reply purported to have been filed by the petitioner on 31/12/2025, which is admittedly beyond the period of 7 days mentioned in the notice dated 19/12/2025, perhaps was not taken into consideration by DMC authorities prior to issuing the impugn notice dated 16/1/2026. Where counsel for the GMC therefore seeks time to obtain instructions in the matter. Placed again on 12th.
Till then the operation may be.
In order to enable Mr. Bora to obtain instructions, although notices are not issued, extra copies will be furnished within the course of the day. We give him copies till the next returnable date. No steps be taken by the GMC pursuant to the impugn notice dated 16/1/2026.
Please, your lordship.
Yes.
We are aggrieved by the impugn order at page 58 and impugn notice at page 59. Order dated 20/02/2024 and notice dated 11/07/2024. Lordship, we were not aware about that eviction drive will be issued to us, but eviction drive will be taken in our village. We only came to know after the heroin incident which took place on 22/12/2025. that the authorities are contemplating to evict us from the villages. 2 villages, Lordship. One is Bagisa Dubi and Raja Dubi villages. There are almost 194 houses are there, and total population is, Lordship, I have the next total population 1,200 something, Lordship. Now, if your Lordship comes to page 58, this is the order.
Yes.
The assistant revenue officer, Donker Revenue Circle, we falls in under the Donker Revenue Circle. By letter number so dated 17/2/2024, submitted the report of encroachment and construction of temporary and permanent structure on PGR VGR land under Donker Revenue Circle. Whereas the Honorable Supreme Court of India in the case of Jagpal Singh and others versus State of Punjab issued a direction to all the state to take necessary steps for eviction of illegal and unauthorized occupants of the Gram Sabha, Gram Panchayat land, and the land must be kept for the common use of the villages. Lordship, this is regarding VGR and PGR land, but in the here it is not the PGR or VGR. I'll show that, Lordship. Now this impugn notice, Lordship, at page 59, notice to vacate the land. All the persons who entered into possession of the government land and the land reserved for grazing, PGR, VGR.
You are agreed by which this notice?
Lordship, notice.
It was issued in 24.
Lordship, we were not aware because neither the authorities has affixed this notice or the order in the conspicuous places or
now how have you been made aware?
We came to know only after the incident, this heroin incident which took place on 22/12/2025, that will be evicted. Therefore, Lordship, I have stated in my paragraph 2, Lordship. In paragraph 2, I have stated detail. If your Lordship comes to paragraph 2 at page 42.
What is this order that you are enclosing?
This is the coordinate bench order, Lordship. That order is of 26/7/2024. Paragraph 5 at page 142 is the relevant, Lordship. We went to submit our representation, but they have not accepted the representation in the Lordship.
No, but this is a grazing land, isn't it?
No. These are neither PGR nor VGR land. Great.
Yes, Mr. Sutia, what steps are you taking?
Well, the petitioner in this petition, there are 195 petitioner. No statement was made by the petitioner, my lord, individual petitioner. What is the land occupied by them and what is the area of the land they are occupying, my lord? And the administration of tribal areas, my lord, rights over the land, my lord, the petitioner does not have that right, my lord, over the land. If the petitioner does not have any right of the land on the PGR land, my lord, in this case, my lord, it is in respect of the land reserved for the grazing, my lord, PGR land. And if the petitioner does not have any right on the PGR land, my lord, so, my lord, the eviction notice, my lord, earlier, my lord, it was issued on 11/7/2024. And if the petitioner is having the land, my lord, then they should approach the authority, my lord, with an individual application.
Yes.
Earlier, this honorable court passed the order on that line that the individual application is required to file demarcating what is the area of land they are occupying and in the if it is in the government land, not in the PGR land. And in the petitioner has not stated anything about the individual petitioner, what is the area of the land they are occupying and whether they have right over the land. So, my lord, there is no interference of the notification that is issued by the 11/7/2024 by the ARO and the order issued by the principal secretary, my lord. That is 22/2024, my lord. 2012/2024, my lord. 22/2024.
Lordship, may I submit? Our forefather came here in the year 1943.
Where is that document, my lord? All the petitioners, my lord. If the individual petitioner have, my lord, right, my lord, that is a different thing. Here is 195 petitioner. What is that particular statement? That particular individual came to the autonomous council area, tribal areas on so and so date, and they are occupying that land. If that statement is not there, my lord, then the and no document to rely on that statement, my lord, on the basis of the verbal statement, my lord, made in the court, not on oath, my lord, lordship may not interfere it.
I've stated on oath. There are 17.
Individual petitioner, my lord, not the, on the basis of the general statement.
Para?
There are 17 at page 51 that in spite of the fact that the petitioner from time to time, time of their forefathers spending.
But where are the
50 years.
particulars of the land under your occupation? You say that your forefathers were there.
Yes.
What are the particulars of the land?
Particulars of the land, we went to the authorities to submit our
At least the
representation.
petitioner
to the
should file, my
particular.
lord, start, my lord.
That you have done recently.
Yes,
But you claim to be in possession of the land since the past 80 years.
yes, 80 years.
So 80 years, you don't know what the particulars of the
Yes,
land.
we know particular, but
Then-
because of the, because since the application, individual application along with the particulars was, we went to the authorities to submit.
Why have
For
you
the
not
respondent number
enclosed
5 and
the
6.
petition?
Lordship,
Why have you not enclosed at
And
least some
yes.
of them in the writ petition?
because Lordship, individual, it will be voluminous
Some of them-
therefore. It would be voluminous.
Some of them.
Some of them we have in annexed. Lordship.
Where?
Yes. At paragraph, page 62 to 92. These are the,
This is only grazing
92.
permit.
these are the,
These are grazing permits.
yes,
Uh,
raising permit as well as revenue, Tozi.
No.
Tozi also we have paid, Lordship.
No. Where is it? These are only grazing.
I am coming. At page 80, Lordship, revenue paying receipt. Then 84, Lordship. You will find the 1965
Some of them
voter
are
list
here.
at page 95.
Some revenue paying.
Yes,
My lord, this is the Toji revenue, my lord, and the for one document that learned friend referred, it is regarding the grazing land,
Grazing.
my lord. In that Supreme Court has already, in that particular case, Jagpal Singh case has already been stated, there is no right on the grazing land and the authority can evict the persons, my lord. And if the person is occupying Toji land, it is the government land, my lord. And the person, only one person's, one revenue receipt has been annexed. The petitioner is required to submit a cert showing the name of the person, my lord.
Done before the authorities.
My lord, so the, it is
Let
a
them do it
lordship,
before the
lordship
authorities.
record by statement and the direction may be issued to the petitioner submitted
Yes.
individual representation stating the area and the boundary of the land also, my lord. So that, my lord, they authority can examine.
Whatever is there, you make verification and find.
My
out.
lord, my lord,
Whatever materials they have, they will submit it.
My
before
lord,
the
my lord.
authorities.
that direction may be.
Third counsel for parties, the petitioners. How many are there?
195, Lordship.
195 in number. Claim to be residents of
Of Bagisa Dubi, village Bagisa Dubi and Raja Dubi.
village Bagisha to be in
Raja Dubi.
Bagisha to be in
Bagisa Dubi in, under Mozak Donka Revenue Circle.
There are two villages.
Two villages. One is
Bagisa Dubi and
Bagisa
Raja
Dubi and another is Raja Dubi.
Under which Moses?
Under Donka Revenue Circle.
Under the Donka Revenue Circle in the district of
In West Karbi Anglong.
West Karbi. The learned counsel for the petitioners submits that all these petitioners belong to the Gorkha community. that are cattle grazers and agricultural daily wage laborers and cultivators. It is the claim that since since
Yeah, 1943. 1943 onwards.
1943,
43.
their forefathers have been residing in these areas as cultivators and grazers, and the petitioners, being their descendants, have continued to do so. While the petitioners have been paying the forest department the necessary charges for grazing permit, as also for the revenue on the lands on the land on which they claim to be under their occupation, copies of which are enclosed to the petition. Petitioners were surprised to be informed from the revenue authorities that they're likely to be evicted. They're likely to be evicted in view of notice which was issued as far back as July 2024. So, copy of this notice is enclosed as Annexure B, your petition. So, the counsel for the petitioner submits that the petitioners were not aware of this notice, and it is only after the recent ethnic violences which had erupted in the West Karbi Anglong district that they came to be aware of the existence of this say notice. So, the petitioners submit that no specific or individual notices have been issued, and the petitioners have received verbal I have been verbally informed that they will be evicted from these lands in terms of the eviction notice dated 11/7/2024. Being agreed, the petitioners are before this court. Para Mr. J. Chutia, learned Standing Council, Karbi Anglong Autonomous Council, strongly objects to the submissions made by the writ petitioners. It is submitted that these petitioners have been claimed to be in the said lands for last several decades, but there is no specific description of the land under their occupation which have been spelled out in the writ petition. Although references have been made in respect of payment of land revenues and forest dues, the specific particulars pertaining to the land stated to be under their occupation is not
petitioner does not have any right
specified in the writ petition, and therefore they cannot have any right over government land or PGR/VGR lands in view of the judgment of the apex court in Jakpal Singh reported in so and so. The learned Standing Council, however, submits that if the petitioners have any particulars of the land under their possession, then they should furnish the same before the authorities concerned.
Respond number 6. Respond number 6, my lord. Earlier, right.
Para.
Along with the representation also. Along with the representation.
In view of the submissions made and upon perusal of the writ petition, this court is of the view that ends of justice will be met. This writ petition is disposed of at this stage without issuing notice, directing the petitioners to submit the particulars of the land stated to be under their occupation, along with all relevant documents to substantiate their claims before the respondent number six. So the petitioners must ensure that the land particulars are permitted to be submitted before respondent 6 must be on individual basis.
Within a specified period.
If the petitioners are able to submit such particulars before the authorities as permitted by this court within a period of 15 days from today, then the respondent authority will thereafter examine the case and pass appropriate orders thereon within 4 weeks thereafter. Stop. Until such orders are passed by the respondent authorities, the authorities will not proceed to evict the petitioners.
In respect of petitioner, who have submitted the representation.
Will not proceed to evict the petitioners who had submitted the particulars along with a representation as permitted by this court. So, if in the event, in spite of the liberty granted, the petitioners or any of them do not furnish the particulars before the respondent number 6, then the respondents will be at liberty to take action as per procedural law. If matter therefore stands disposed of in terms of the above. Copy of this order be marked to the Office of the Standing Council, AAC, for communication. Disposed.
Made the motion. The petitioners are an office bearer of a bazaar, which is operating since 1937 over a plot of land. Now with the time, my lord, if your lordship will kindly see page 58, this bazaar got extended to two different dags, my lord. One is a annual patta dag, which has been classified as a Bepar time, my lord, as a market area in 147. And another plot of land, which was a government khas land, my lord, then 148, dag number 148, which has been created due to the change of the river direction. Now, this land were in possession of the market, my lord, since several years. Now, there has been an illegal settlement in favor of respondent number 7, which is a masjid and a madrasa, my lord, in dag number 148. Now, though the settlement has been done, as they did not occupy the land, in the name of delivering possession, for the sake of delivering possession, a demarcation was sought to be done, without issuing any notice to the possessor, who is the bazaar, and also the bazaar is a pattadar, adjacent pattadar. It is a requirement under law, that they have to be served a notice. Now, thereafter, we have filed several appeal before the Deputy Commissioner against the illegal demarcation and for cancellation of the settlement. Now, if your lordship will kindly see, we have been repeatedly requesting the circle officer to do a physical verification in presence of the petitioners. And in fact, page 96, the additional deputy, 93, the additional deputy commissioner also directed the circle officer to submit a report, inquire into the matter and submit a report. But despite this, the circle officer has not done anything. On the contrary, the settlement branch, they are trying to deliver the possession to the respondent number 7. Now, this we have been insisting, it is also one of my prayer in the repetition, page 17, if your lordship will kindly see, because this is the only way to find out, who is in possession of the land, because in the name of demarcating the boundaries, they are trying to deliver the possession. Page 17, my lord will kindly see serial number 3, my prayer.
70.
Oh, 171.
17. Roman number 3. Conduct a fresh inquiry.
Yes, madam. Field inquiry. Press field inquiry. The reason for using the word fresh, madam, because our demarcation was sought to be done on 12/11/2025. Madam, due to some breach of peace and tranquility in that locality, madam, they could not do it. But we don't know what report has been submitted by the circle officer pursuant to that demarcation. Therefore, we have asked for a fresh field inquiry, madam.
In 1612, last and page lordship, we have forwarded to the circle officer on 1612 lordship. I think
Page.
last page 96, 96.
96.
90, more of 96.
96.
Last page. That is serial number 3. That is that.
No,
was
no, no,
submitted.
that is regarding petitions. Did you conduct the inquiry, field inquiry?
Not yet.
Lordship. Yes, lordship. That I have the instruction. What is the outcome of this? Lordship.
All right, heard. Mr. P. Kaushik, Leonard County Petitioner, Mr. M. Goswami, appearing for the respondent.
I'm for
Number
456.
4, 5,
6.
6. It's T.R. Monto for respondents. 1, 2, 3. 1, 2, 3.
3, yes.
The grievance of the petitioner is that the point of discord between the petitioner and the private respondent number 7 is a plot of land which the petitioner claims the revenue authorities had wrongly demarcated the same, and in the process of demarcation are now attempting to hand over that parcel of land to the respondent number 7.
Madam.
The learned counsel for the petitioner submits that there was a field inquiry sought to be carried out on
12/11/2025.
12/11.
12/11.
25 in the presence of both parties. However, because of breach of peace and communal tension, the same had to be avoided. Stop. Meanwhile, the petitioners now apprehend that some report has already been submitted by the circle officer.
By the circle officer.
Before the district commissioner Hailakandi, by which the said disputed plot of land or parcel of land may now be demarcated in favor of the private respondent number 7. Stop. He therefore submits that there should be a fresh field inquiry, and until the same is done, the status quo be directed to be maintained between the parties. Whereas Mr. Goswami, on the other hand, is referred to page 96 and Annexure 13 to submit that the prayer petitions in regard to the disputed parcel of land has been forwarded to the circle officer. However, he does not have instruction as to whether a detailed report has been received as on date. He prays for time. He seeks liberty to complete his instructions. Accordingly, let this matter be listed on when can you have it? 4th
February. So, I mean, 7, 12.
13. 13 February, by which time the State Council will apprise the court as to whether any field inquiry was conducted between the parties and the report submitted, if any, thereto. Stop. Meanwhile, till the next date of listing, the status quo be maintained. with regard to the said parcel of land by the parties concerned, which however will not restrain the respondent authorities to conduct a field inquiry if the same is contemplated by the respondents in the meantime. This
I will-
recording.
Respondents are the private respondent or the, that's on number 7.
The petitioner will ensure service of copy on the respondent number 7 by Dusty, routed through the office of this court.
Both
Registry of this
Dusty and
court.
registered postman. Both Dusty and registered.
We are not issuing notice now.
Dusty will try, my lord, because there is a it may lead
Well,
to
you
another
try.
risk.
We'll see. There may not be requirement to issue notice also by the. next
Possibly.
year. This is the-
Grateful. Lord.
Dated it for order item 26.
May I, Lordship, in this case, I need to file a chart, Lordship.
Huh?
I have to file a chart, Lordship.
Chart for?
Regarding Lordship, the what amount Lordship they of land Lordship, they have got compensation as per last order Lordship. 3/12/2025. Lordship, I may be allowed 1 week time Lordship. I have communicated with the
Counsel for the petitioner prays for further time to place before the court the chart reflecting the status of each of the portion of the land over which the petitioners claim that they have not been paid compensation for acquisition. Matter therefore be listed after 4 weeks. Later, so and so appears for the respondents.
I'm
Yes.
respondent number 2 and 7.
27.
এখন থাকুন।
Yes.
May I please your lordship? The petitioner have challenged the order passed by the Board of Revenue in granting mutation in favor of the respondent number 6. The facts of the case is this, my lord. The one Parasuram Morali was the owner of the land. Landowner of
No,
the,
no, but today it is for orders. Why is it come for orders?
pleadings are completed. my
Readings
lord.
are complete. Okay. Some additional affidavit was filed for rectifying of some,
Rectifying the fact.
that is also done.
Yeah.
We'll queue it for admission hearing.
My lord, case is very short. You lordship may kindly fix in the first week of February.
First week of February.
Oh, my lord, the second week of February, first week I may be out of station. On 9, 10, 11, any day.
All right, 10th,
10th.
10th of February.
Okay.
It is submitted by the council for parties that pleadings are exchanged in the matter. Matter can be attempted to be disposed of at the admission stage, list on 10th of February as agreed.
My lord, an attempt may kindly be made at
Attempt
the
will be
admission
made-
stage because subject matter is very short.
Attempt will be made to dispose of the matter
Yes.
on the next date of this.
Thanks. All right, all right. Oblige.
Some land was settled in favor of the petitioner. That your lordship will get it at page 28 of the week petition.
Hmm.
Then thereafter, my lord, we challenge this and your lordship will issue notice. But in the meantime, we have filed an IA saying, my lord, that some unauthorized persons are carrying on constructions on the land.
Hmm?
Some unauthorized persons are carrying on constructions on the land.
Hmm.
That your lordship will get it at page 15.
Hmm.
14 and 15, and we have filed FIR also at page 13.
Hmm.
And in reply to this, my lord, they have shown that they have asked them not to carry on the constructions. Still page 20 of the reply in IA.
May I plead your lordship? Lordship, I am for.
Page 20, they have said, my lord, the council has filed an affidavit in the IA. It says, my lord, with reference to the above, it is reported that you have started constructions of structure in the disputed land of so-and-so memorial trust. Therefore, you are hereby asked to stop construction, but yet construction is going on. I pray, my lord, in the meantime, affidavit has been filed now and the private respondent is also there. They have to file affidavit. Let the status quo be maintained, otherwise things will carry on.
Yes.
Your lordship, may I plead your lordship? Your lordship, I am for opposite party number 123. That is your standing council. That is your lordship for the North Coastal Hill Autonomous Council, the secretary and the additional secretary. Your lordship, as per the prayer that has been mentioned by the petitioner side, that is that their prayer, your lordship, was that.
Who is for the private respondent?
I'm appearing for the private respondent number 4.
The lordship, the petitioner's prayer was to take appropriate action for preventing the unauthorized construction over a plot of land measuring 250 acres. The lordship, us being a administrative council, the lordship, as much within our power, we have duly issued a notice to the encroacher, that is the that is your lordship, Amal Thousand, Gaon Burhav, Digbam Razi, to cease any construction activity on the disputed land, if any, until the matter is resolved between the parties.
Now, what do you say, private respondent? Why have you constructed?
I am for, I am filing a additional affidavit.
They have not constructed, my lord. They were originally, my lord, they were the trust. The land belonged to them. It was cancelled and it was settled in favor of the petitioner. So somebody else is constructing in the open eyes of.
No, the communication that you showed.
Yes.
Referred to.
Page 20, my lord.
Is to the Gaubura.
It is to the Gaubura.
So is the Gaubura party here?
No, Gaubura is not, it says, my lord, it refers to the above, it is reported that you have started construction. According to us, my lord, Gaubura has not done anything, but they have given a letter to the Gaubura. So, whatever it is there, my lord, I think, my lord.
No, but who is that party who is constructing?
Lord, the party's name is not there because
then
somebody,
who will ensure maintenance of status quo?
they will mention, my lord.
The lordship,
Council will mention.
the lordship, we need to seek the instruction for further instruction, whether any development.
Council will maintain, my lord. Otherwise, things are not going. Today, this person, today, tomorrow, that person.
The lordship, after the essential notice, we need to take further instruction regarding a development about the whether the activity has been ceased or not, your lordship.
Council will ensure.
Where is the interim order?
There is no interim order. Your lordship has issued notice. And the point is, my lord, whether the cancellation is right or wrong. Cancellation of the settlement without hearing, without issuing any notice.
Yeah, what was cancelled?
The settlement order.
Where is that?
That is at page 28.
28.
Type copy is at page 27. Hereby cancelled. Treated invalid until further also. And reallotment of the same shall be made when the dispute is settled amicably by the parties in the Dima Hasao Autonomous Council court. There is no court, man.
What is the status in the council court?
There is no council court, man. They have just wrongly written this. There nothing has been done. Matter has to be decided by the council after hearing the parties.
I had heard counsel for parties. Petitioner before this court has challenged the order dated 2002-2025. issued by the Dimahasa Autonomous Council, Haflong. By the said order, land measuring 245 acres covered under AK Patta number 3, tag number nil, which was allotted to the writ petitioner, stood cancelled. And the reallotment of the same is to be made when the dispute has been amicably settled between the parties in the Dimahasa Autonomous Council court. Stop being agreed, the writ petition has been filed. Notice in the matter was issued as far back as 4/8/2025. During the pendency of the writ petition, in the said land, which was earlier allotted to the writ petitioner and subsequently cancelled, the petitioner now claims that some unauthorized construction has been initiated. And for which the petitioner has filed an IA, being IA number so and so, praying for interim orders. The further contention of the petitioner is that there is no Dimahasa Autonomous Council court and no matter pertaining to this cancellation, to the best of the information of the writ petitioner, is pending before such a court. He therefore submits that if interim orders are not issued, then during the pendency of the writ petition, if the unauthorized construction is allowed to be carried on by the Dimahasa authorities, then the writ petition will become infructuous. Mr.
And we are on behalf of D1000.
And we are
On behalf of D1000, the standing counsel.
appears on behalf of Mr. D1000 as standing counsel of Dimahasa Autonomous Council. And MS J. Gogoi appears on behalf of respondent number 4. So Mr. Bhuya
Yes, Your Lordship.
submits that the Autonomous Council has already issued a communication dated 12th of November 25 to the Gambura of Dibram Raji, Dimahasa, directing him to stop construction of works in the said disputed land. Therefore, the authorities of Dimahasa has not permitted any construction in the said land. But having heard counsel for parties, you have filed your
Yes, Your Lordship. We have filed
affidavits in the writ petition.
Yes, Your Lordship. We have filed the agreement in the writ petition also and IA also.
The parties have exchanged their affidavits. Therefore, the matter can be posted for admission
Yeah, thank you.
in the first week of March. Let the matter be listed again on 6th of March for admission. Meanwhile, the Dimahasa authorities will ensure that no unauthorized construction is carried on in the said disputed plot of land, and will take all steps necessary to ensure that status quo is maintained between the parties.
We have not filed affidavit, I think.
We have, Lordship, I have not received any copy.
You have not received.
Lordship.
Why have you not mentioned in earlier?
Lordship.
Counsel for petitioner will ensure service of copies on all respondent counsels
Deeply
within 3 working days.
Deeply obliged.
May I appeal, Lord, sir? In this case, my lord, my learned file I my lord. I have prepared the objection, my lord. AI against the I my lord.
You have prepared.
Yes,
But you
already
don't want to
prepared,
file
my
it.
lord. Could not file due to some technical problem, my lord.
You
Already
already
ready.
file or you don't want to file?
And then, my lord, already I have prepared the work.
Oh. You are preparing and admiring your work. You are not filing it.
Some technical problem, that's why my lord could not file. my lord.
Technical problem. All right. Matter
Lordship,
listed after 2 weeks.
Another petition is filed by the same petition number.
Yes, a W.
The 2 weeks, enabling the opposite party to file its objections to in the IA number so and so connected to the writ petition. It is also submitted at the bar that there's another writ petition.
Writ petition number WBC 5815/25.
WPC 5815/25 has been filed by the opposite party in the IA, and accordingly the present matters be listed along with WPC so and so.
Lordship, fix a date.
And there is the interim.
So and so on 13th of February.
There is the interim order.
Interim order passed earlier, if any, will continue till the next date.
May I please, your lordship? Lordship, Mr. Kyal is on legs at the moment. The matter may be taken up some other day, your lordship.
What is this?
My lord, yeah, my lord, I have silenced an order whereby penalty has been imposed, my lord.
Penalty?
My lord.
What penalty?
Penalty and recovery of, my lord, service tax, my lord.
Oh,
Service tax along with penalty.
all right. On the request made by council, you not filed an appeal.
My lord, but that may not be efficacious because, my lord, my limited prayer is that, my lord, for remanding back the matter, giving us an opportunity to submit some documents, my lord.
All right. List on 10th. 10th of February.
My lord.
Yes.
Lordship, in respect of this matter, mentioned memo was submitted, your lordship. We had obtained the consent of the petitioner also. We are yet to file an affidavit in this matter, lordship.
Why have you not filed?
Lordship, instructions are awaited from the department.
What is the matter?
The appeal was dismissed on the point of limitation, my lord.
Huh?
Appeal was dismissed on the point of limitation.
Limitation. All right. When can you have your instructions?
Lordship, 2 weeks time maybe,
No, no.
by then we'll.
10th.
10th.
List on 10th of February. If you don't have instructions, we'll close the matter.
Then interim order, my lord.
The interim order passed earlier will continue. There are matters where we had passed orders directing appellate authority to reconsider.
Yes, my lord. And with the, in that line can dispose.
Do you have these orders with you?
Right now, I don't have, my lord.
Bring it on
Okay.
10th.
My lord. Much obliged.
Yes.
Lordship, I have taken the instruction from the verbally here, Lordship.
Hmm.
Our stand is on the 30/10/2024 on point number 4, your Lordship.
Hmm?
Point number 4 of this honorable court order dated 30/10/2024.
3010.
30/10, your Lordship.
Point number 4.
Point number 4, your Lordship. Otherwise, your Lordship. It's a premature case to file before this honorable court, your Lordship, since there is an option for go for appeal, alternative remedy.
Yes. Why have you not preferred?
Lordship, because there is a clear violation of natural justice, Lordship.
Uh-huh.
Lordship, the order which we have.
What are you challenging here?
Let's say the interim order has been passed up much beyond the limitation period. Lordship.
Where is that order?
Lordship, the order is in page number, Lordship, 115 to 123, Lordship.
152.
115, Lordship, starting.
You take up all these issues before the appellate authority.
Lordship.
Who says you can't take up the point of limitation on before the appellate authority? Appeal is to be filed within how many days? 60 days.
60 days.
Then
Then kindly take up the matter any day and next week, Lordship. So that my senior can also argue, Lordship.
all right. Come back on 27. 27.
Lordship, next date, if Lordship.
Huh?
27 is,
Inauspicious.
yes, Lordship, I have to at Itanagar.
Huh?
I'll be at Itanagar, Lordship, so from this department.
Third.
Lordship.
3rd of February.
So interim kindly be continued.
Huh?
Interim may kindly be continued.
3rd of February for admission hearing. Interim orders, if any, will continue till the next date fixed. Mr. Dr. B. Gogoi appears for the GST.
Yes,
Here, Mr.
SK Shah, Lordship.
S.K. Saha appears for the writ petitioner. On 3rd,
Lord, Dear Gogoi, by Dr. Dear Gogoi. 55.
Lordship. On the last occasion, we agreed for appointment of an arbitrator. They have not filed their affidavit. They have no objection for appointment of an arbitrator from the panel.
Okay.
3rd, Mr. D. Senapati, learned counsel for the petitioner, and Mr. K.L. Gupta appearing for the respondent. Where is the agreement?
Page 32.
By an agreement. 32.
32, section 20 is the agreement dated page 25, 14 December 2021.
The letter of engagement is page 23.
23, agreement form is at page 25.
Right. By letter of engagement dated 23rd of August 2021, the petitioner who had participated was submitted. It was a bid.
Yes, Your Lordship.
Submitted in a bid
For construction of
for construction of so and so, page number 23. Construction of so and so at an amount of rupees 135,88,87,602. The time allowed for completion of work is 18 months or 31st of December 2022, whichever is earlier, to be reckoned from the date of acceptance of the letter of engagement. So, pursuant to the said letter of engagement, the agreement was executed by and between the petitioner on 14th day of December 2021. Stop. Where is the clause?
Page 32.
In terms of the agreement, in case of any dispute that may arise between the parties, the provision for referring the dispute to arbitration is prescribed at clause 20. Stop. Clause 20 reads as under extract holding. Thereafter,
Dispute have arisen.
Disputes had arisen between the parties. And
We place our claims on 9/6/2023, page 39.
the petitioners raised their claims by communication dated 9/6/2023.
Thereafter, annexure 6, we raised sought for arbitration appointment.
Since these claims were not redressed, where is that?
Page 48.
The petitioner demanded arbitration by issuing a notice under clause 20 of the contract, ID, notice dated 18/8/2023. Stop. Since the said notice, in terms of the said notice, no arbitrator was appointed. The petitioner has approached his court. You suggested the
We
name of an
suggested,
arbitrator.
but for a sole arbitrator, but since they didn't come forward, that has become redundant now. So your lordship will have to appoint an arbitrator.
The petitioners had also, by subsequent notice dated 2009/2023, nominated their arbitrator, calling upon the respondents to concur on the said nomination. Stop. However, since there was no response, the present petition has been filed. Counsel for the respondents, you have not filed any objections.
No.
Submits that they have no objection if the court appoints an arbitrator as per the panel maintained and published by the registry. As per the panel notified by the registry. Stop. Under such circumstances, this court under the powers of Section 11 of the Arbitration and Conciliation hereby appoints
Honorable Justice C.R. Sharma, your lordship.
Let us go with Mr. H.N. Sharma.
C.R. Sharma. Yes. Okay.
Because you should leave it to us now that you are here. Your suggestions did not work.
No, but out of this panel, if I.
Out of this panel, you have no preference. We can choose. We'll go
Or
with,
the district judge.
Alfajili sir.
huh?
Alfajili sir.
Huh?
Mir Alfajili.
Mir Alpha is not here.
He's not in panel.
Panel.
So we'll go with Mr. H.N. Sharma.
In some way, it's slightly, yeah. इसके समय में
H.N. Sharma nominated to act as a sole arbitrator to decide and arbitrate on the disputes arising by and between the parties in connection with agreement number so and so executed by and between the parties. Copies of this order be communicated by the registry to Honorable to Justice H.N. Sharma, retired. And the parties are at liberty to place copies of this order before the prospective arbitrator. Stop. Upon receipt of a written declaration from the prospective arbitrator, the appointment will be confirmed in the next date. Let this matter be listed on 18th February.
Not report.
Ma'am, please, your lordship. Consider matter pertains to appointment of arbitrator, your lordship.
Huh?
Appointment of arbitrator, your lordship.
Ah,
Lordship, This is completely covered. Lordship, what the railway has done, Lordship, they have suggested 4 names from the retired officers from the railway.
Any objections to be filed?
My lord, in fact, the arbitrator has entered into reference. What has happened, my lord, that in terms of the order passed in WPC, my lord, they have at page 40, my lord, annexure 10.
Page 39, your Lordship.
Page 40, you said.
39, it is available.
Page 40, my lord, is the notice by which they have invoked the arbitration. Thereafter, my lord, at page 46, my lord, the railways has asked to, my lord, waive the consent for waiving, my lord, under section 12(5). They wanted to appoint their arbitrator. Thereafter, my lord, thereafter no response was given. Then, my lord, at page 48, annexure 12, when no response was given, my lord, we gave 4 choices and requested the petitioner to intimate within 30 days. To which, my lord, no reply came, my lord. Then the railways appointed the arbitrator, page 49.
Well, you can't do that.
But and thereafter, my lord, at page 50,
Completed the horse of the.
at page 50, my lord, the arbitrator has already entered into
You cannot,
reference.
this is totally illegal.
My lord, then they have to approach under section 13, my lord, to challenge.
No, it's not a question like that. You can't
11(6).
do arbitration like this. Under the statute, they'll have to, they are at liberty to waive.
No
If the
reply
waiver
was
is
given
not
by,
there.
no reply was given by the.
we have
No reply
objected,
is not
Lordship.
the ground.
We have
No reply
objected.
is not the ground.
Rightly or wrongly,
It is
the
not-
arbitrator has
not
entered
a
into
question of
reference, my
rightly or
lord.
wrongly. You cannot be allowed. You are a state instrumentality. You
in my humble
cannot,
submission,
you
the-
cannot be permitted to twist a law
My lord.
to defeat the very purpose.
No, whether 11(6) would be maintainable, my lord. In my humble submission,
The
section
11(6)
13.
maintainable or not is a different issue, but whether
Section
you are
13, my lord, they
authorized,
have to challenge that appointment
no, but
procedure.
whether you are authorized to make an appointment unilaterally, show us any power under
That is.
the arbitration.
That is.
Notice that is
And then you have the audacity to come and defend your actions. To say
No, Lord,
that
I
this
am
can only be
in the
challenged
proce-
under section 13.
My lord.
Who is this person who has given you deputy chief engineer?
My lord.
We'd like to learn some arbitration from him. Can you call him, please? We'd be benefited by his deep insights in the law of arbitration.
Lord, in the earlier communication, my lord, at page 48.
Under what provision has he decided to twist the provisions and go ahead?
That is incorrect, my lord. That is, I agree to that.
If you agree, why are you defending such undefendable actions?
Lord, I am just intimating, my lord, that the arbitrator has entered into reference, my lord. So that,
Lordship, that is closed, your Lordship. After we
no,
have-
where is this?
Lordship, after this constitutional bench judgment.
No, you file your objections. We'd like to know under what circumstances has he appointed this? Or we are calling him in person?
Lord can appoint, my lord, in that case.
No, no.
taking Note of the order, my lord.
No, no, this kind of high-handedness cannot be tolerated. What is this? That you feel like in matters where people are crying out, dying, approaching the railways to appoint arbitrators, you don't appoint. And in some matter, you decide to go and appoint unilaterally when there is no waiver. And then you say that, no, it's already gone, you want to challenge it, go and challenge under 13.
My lord can appoint, my lord, in that case. I have no objection.
You make up your mind and tell us.
No, no, that can be appointed.
What is the status of that arbitration?
Lordship, Lordship, after we have objected, then the Lordship arbitration process, Lordship, they have not committed because the arbitrator was telephonically contacted with the petitioner, Lordship, after the.
You bring it on record by way of an additional
Yes,
affidavit.
Lordship, please.
Bring it on record. Counsel for petitioner is permitted to file an additional affidavit to place necessary material facts which had taken subsequent to the filing of the petition. Mr. Gupta appears for the railways. List accordingly. Yes.
Lordship, my learned friend may also, yes, before the about
I
the
will-
status of the, because they have not contacted with us after the objection also.
17/4/25.
Lordship, this is the
Mr.
31st
Gupta,
May.
will also obtain the required instruction from the railways if any arbitration proceedings have in the meantime been initiated by the railways unilaterally and the status thereof.
No, no, this is the proceedings have already been, I will take the instruction on the
Take it and
current,
bring it on record.
current status of the proceeding.
Yeah.
Lordship, Lordship, if may, Lordship, I pray for a date, your Lordship.
Thirteenth
13th of.
13th February.
Keep development.
Well, so this is also for appointment of an arbitrator. The respondents have filed their affidavit.
We have filed our affidavit today during the course of the day. Lordship, can I take up this matter after we close? Along with the.
You have filed it.
Yes.
The only objection is that during the pendency of this application, they have nominated an arbitrator. That will be governed by Datur.
The Mr. D. Senapati for the petitioner and Mr.
L. Sanktam, Lordship.
L. Sanktam appears for the respondent, who submits that an affidavit has been filed during the course of the day. The registry will trace out the affidavit and connect it to the case record. List again on 13
Yes, sir.
13 February.
Not deeply. Look, I is fine, madam. In fact, to amend the petition, madam. To amend the petition, madam. But the petitioner before your lordship, madam.
You want
Elected members of my lord.
You have filed an IA for amendment.
Amendment. And during the pendency of the petition, madam, we came to know that there is an order, madam, passed against us, madam. And that order has to be, madam, being on.
Any objection?
I am for respondent number 6, 7, 8, and 9, private respondents. We have filed a written objection to the IA.
For amendment.
For amendment,
You
they
are
have filed the IA.
Ah,
We have filed objection to that IA.
why?
Lordship, they have said that they have received that order after filing this case. But as per our information, they have received the order earlier filing this case only, filing this writ petition. And then there are some mistakes on the names of the respondents. That also we have mentioned in our affidavit in reply. And mainly we have objected to their IA. Paragraph number 3, page number 3, your lordship, we have mentioned that the petitioners have stated that they received the order issued by the opposite party number 4 by notice number so-and-so, dated so-and-so, a few days back, before filing the writ petition. However, lordship, they have not mentioned the exact date of receipt, lordship, nor have they enclosed any proof of receipt. It is submitted that as per the knowledge and information available to the deponents, the petitioners were in possession of the said order prior to filing this writ petition, lordship. But they intentionally avoided annexing that order in the said writ petition. That is where we are filing this objection, lordship.
You are appearing on whose behalf?
6, 7, 8, 9. Respondent number 6, 7, 8, 9.
But this order is there any can there be a restraint for them to bring it on record? This order.
They could have mentioned it. They could have annexed this order, your
They could
lordship.
have.
They could have.
Could have.
And that intentionally they have
Now they-
avoided.
Now they
Madam, kindly look, madam, kindly peruse my paragraph 9, madam, in my, madam, I am, madam, paragraph
now
4,
they
madam.
want
They have
to bring
replied.
it.
Yes.
Had
That
it,
are
had
during
it
the-
been a case
They
that,
have not mentioned a few days back, they have not received,
During
announced
the
any
pendency
proof
of the
of-
writ petition, my lord, a few days back.
no,
that exact date is not mentioned, Lordship, and also they have not mentioned that any receipt of that any proof is also not annexed to your Lordship.
no, is it your case that this order is not necessary for the decision, for deciding this matter?
Yes, your Lordship. Now,
Number two, that this whole purpose of attempting to bring this order is to delay the
yes,
litigation.
your Lordship.
Or number three, that this order is totally irrelevant for the present proceedings.
Their intention is to delay this, your Lordship, and give us harassment, your Lordship.
So we'll allow the IA with a cost.
Yes, your Lordship, that can be done.
Well, delaying from my side.
So
does
why
not-
have you not brought it on record?
Yes.
Well, at that point of time, my lord, we have not received that copy. my lord.
Then when
they-
did you receive it? She's raised.
My lord,
an
during a
objection.
peninsula writ petition, my lord, we came to know that, my lord, this type of order has been passed.
She's raised an objection that you have not mentioned the date when you came to be aware of.
The date is also not mentioned, and any proof of receipt is
No,
also
during
not
the
mentioned.
pendency, my lord, but because of this order, we have to challenge it.
No, it can't be that. during
That
the
is
pen-
inevitable, that is the main order they have to challenge, then they have not.
You may,
Next
you
date
may
during
make
the-
a statement to
fine.
say that inadvertently it was left out.
No, this is not invalid, my lord. My lord,
But
we
if
have
you
not
say
received
that-
that copy, my lord.
if
But
you
if we
say
received
that
that copy, my lord, we have challenged it, my lord, in earlier occasions also.
If you say that it was not available,
Madam.
then you have to mention it.
But even, my lord, this order was passed on, my lord, for, my lord, 14/7. We have filed, my lord, representation on 19, my lord.
Before filing the
no,
repetition,
no,
the order has been
my lord,
passed,
no-
your Lordship.
Oh, such order has
And
been
it was
passed.
in custody
Today, my
of
lord.
everyone.
What? The order.
My
was
lord, this,
passed on
my lord, kindly, my lord, this order has been passed on 14/7, my lord. Kindly see my repeat, my lord. We have filed representation.
14/7.
My lord,
14/7 order has been passed,
Passed.
they have filed it later than.
Even on 19/7,
On 19/7 they
we
have
filed
filed
representation
repetition.
before the
You
consult.
filed your writ petition on August.
Madam.
So the order was available with you.
Not available. That's why on 19/7/2025, we
Yeah.
have filed a representation before the concerned authority that the matter may be settled, my lord. But that has not been settled, but the order has been kept, my lord.
Where is that representation
That is page 36, my lord.
of?
Read my read petition, my lord.
This is the government order and it was available to everyone. It was available on website also. It is very illogical to say
But
that
this
they have
type of-
not received
my
it.
lord,
Yes. Where is
kindly, my lord, page, my lord, first, my lord, page, my lord, 34. This is a reschedule, my meeting was rescheduled on my lord, 14/7. Page 34, my lord, can you have a look, my lord.
Mhm.
Reschedule, my lord. And my lord, on 35, my lord, can you have a look, my lord. There is a corrigendum, my lord, that was issued. And after that, my lord, no order has been passed, my lord. And during the pendency of the writ petition, my lord, we came to know that my this type of order has been passed, my lord.
Where is that order?
There is my lord,
In your eye?
in my eye, my lord. And next slide, please.
Page?
Last page, my lord.
Last page is not legible.
They provided the, my lord, type copy, my lord, reported. Even in that, my lord, meeting, only 4 members were present, my lord, out of 10 members. The petitioner before your lordship is 6 members, my lord, petitioner before your lordship.
So this order you want to challenge?
Madam, we are. We are not present even at meeting or somewhere. If any such type of meeting was held.
So you will allow it to pay cost? You have not explained properly.
Minimum cost, my lord.
Minimum? What minimum cost? You are the GP member.
Respondents.
Right.
Most
President,
bit
GP
respondents has to come from Lakhimpur to
Ah.
Guwahati to sign this papers, your
The
lordship.
respondent number 6, my lord,
6, 7, 8, 9. They are coming from Lakhimpur to Guwahati to sign the
delay
affidavit.
does
and
not
all.
arise, my lord, because
My lord, the respondent is.
It is their negligence, Lord,
Heard
my lord.
counsel for parties, this IA has been filed seeking leave to amend the writ petition and for assailing the order dated 14/7/2025 passed by the Office of the Block Development Officer organizing. In the accompanying writ petition being WPC 4423 of 25, the order, according to the petitioner, the order ought to have been assailed. However, at the time when the order was passed, at the time when the writ petition was passed, the applicant writ petitioner claims that the present order dated 14/7/2025 was not available with them. Now that counsel appearing for the
6789.
count, appearing for respondents
6789.
6789 strongly disputes the contention of the petitioner. It is submitted that this order was always available with them, and therefore this ought to have been challenged in the first when the writ petition was filed, as the writ petition was filed pursuant to the orders passed. Therefore, the amendment sought to be made in the present application is nothing but an attempt to delay the proceedings. And therefore, the amendment sought for is unwarranted. Having considered the submissions made by the counsel for the parties and the pleadings on record, this court is of the view that the order dated 14/7/2025 is sought to be challenged by the petitioner. The petitioner has sought to has sought amendment on the ground that this order was not available with them, but subsequently came to be available, which statement and contention is strongly disputed by the respondents. Nevertheless, fact remains that if the petitioner seeks to challenge the order dated 14/7/2025 and thereby seeks an amendment to the writ petition, this court is of the view that the same should be allowed. However, after payment of cost for petitioner not being diligent at the time of filing the original writ petition. Accordingly, this IA stands allowed subject to payment of cost of rupees 2,000.
2000 per respondent, Your Honor.
No, 2,000 to the respondents. How many respondents?
4 respondents. Your Honor.
4 respondents.
6789 private respondents. The government is also.
All right, you say you for the time being you settle for 2,000. At the time of disposal of the writ petition, you can increase the cost if required. All right, 2,000 to be
Moreover, your
to the respondents through the counsel representing the respondents. Stop. Upon due payment, the petitioner will be petitioner should file amended writ petition. Upon due intimation to the registry regarding the payment of cost. List accordingly.
my lord, there are some other mistakes also. They have made mentioned our names in a wrong spelling.
In the amended petition,
In the amended petition, they should correct that also.
You raise these objections if it is there in the amended writ petition.
Yes.
If required.
Yes. Obliged.
deeply obliged.
This Lordship.
Affidavit.
Lordship, we have not filed an affidavit, but some notification has been come, Lordship, where inter-region land transfer, some notification has been published, Lordship. Inter-religion land
This
transfer.
is actually Lordship, application for issuance of NOC in regard to inter-religious land sale transfer, Lordship. So there was a procedure prescribed in notifications at page number 50, Lordship. Which was in force, Lordship, while that applicant has applied for NOC, Lordship. And it is the mandate of the Registration Act also, Lordship, that the NOC may be issued within 30 days, Lordship. But it's deliberately, the respondent has not even disclosed this application, Lordship, and they have put it on hold, Lordship. Lordship may find at page number.
Yes, what is that instruction?
Yeah.
Piece of page.
That notification, Lordship, has been subsequent, Lordship. It is not applicable to our case, Lordship. This was the second time. In this notification also, Lordship, the Lordship, if Lordship peruse the 0.7, Lordship, it is clearly written, Lordship, in the event that an application is not disposed within 30 days from the date of application, the District Commissioner will issue speaking order with reasons thereof to the applicant within the said stipulated period, as per the provisions of Section 21A, Lordship. Whereas in the instant case,
You
Lordship.
tell us what is there here. Why have you kept this pending?
Because
what are your instructions?
According to this notification, Lordship, that real number, next page, Lordship, 123, Lordship. And applications for a grant of NOC for transfer of land shall made by the applicant through Seva Setu portal to the officer.
But there has to be, are you saying this on instructions or what? In respect of the writ petitioner, he has submitted this
application
to Seva Setu.
Lordship.
So what has happened? Why are you not able to get the instructions?
Lordship, almost 7 times they have taken time, Lordship, and the petitioner is a widow.
This is the last time.
Lordship, petitioner is a widow, Lordship.
This is from Sri Bhumi.
Yes, Lordship.
You get instructions or you'll have to call your DC.
The 30th, Lordship, 30th of January. 30th of January.
30.
Lordship.
30th.
Lordship.
All right. Matter be listed again on 30th of January, enabling the government council to fulfill his instructions in the matter.
Just a minor lordship there. That may be noted, that is the last opportunity may be given to them.
Not necessary. You renew your prayer.
Obliged.
Yes.
May I please, your lordship? My lord, I have a biryani shop, my lord, in the name of Sahi Biryani in my lord Nil Bagan. My lord, and doubting that some objectionable meat item, my lord, had been sold in my lord biryani shop. Suddenly an order, my lord, without giving me any opportunity of hearing or so cause. My lord, the impugn order came to be passed at page 35, my lord. Now, my lord, I have put into challenge this order, my lord, on the very grounds that the procedure which is required to be followed, that has not been followed, because, my lord, the deputy commissioner has issued this order, my lord, in the capacity at under section 152 of the BNSS, my lord, to prohibit the nuisance. Now, my lord, an affidavit has been filed, my lord, recently, just before the vacation, my lord, and we have gone through the affidavit, my lord.
Who has
And
filed?
that affidavit also, my lord.
Who has filed?
The affidavit has been filed by the, my lord, deputy
No, it is not available.
respondent number 5, my lord.
It's not here. You have been served with a copy.
Yes, my lord.
Mr. Goswami,
Lordship.
you seem to be in doubt. Affidavit filed or not?
But I have received and it had been notarized, my lord, also. Oh, record of nothing.
The government council is not aware whether it has been filed.
My lord, I am on very big trouble, my lord. This is my only source of livelihood. 25 family members, including, my lord, the employees, my lord, are on road, my lord. So, my lord, can some interim protection, my lord?
Regarding what?
That my shop has been seized, my lord. So, my lord, with certain terms and conditions, if my lordship allows me to operate my business, my lord.
No, but if some affidavit is filed, then
Lordship.
My lord.
We have submitted copy to the veterinary department also. Lordship. He has received, so I have to check.
you have filed something.
No,
Lordship, I have received the
copy.
Lordship. I am for the veterinary department.
Court to file.
You have received the copy filed by whom? Who has filed the affidavit?
Deputy Commissioner.
Respondent 5.
District Commissioner.
My lord, the district commissioner Hujai, my lord, has filed it on 18/12/2025, my lord. Prima facie, my lord, order is not maintainable because, my lord, I have gone through the provision of section 152, which is required to be read with the, my lord, Cattle Preservation Act, my lord. That is also.
Yes, Lordship. We have filed it on 2012-25.
It's not here. Mr. A.R. Bhuya for the petitioner, Mr. N. Goswami for state, and Mr.
Lordship, DJ Boro Lordship on behalf of J.K. Goswami.
DJ Boro on behalf of J.K. Goswami. The respondents claim to have filed an affidavit on
2012-25.
from 2012, not 2025. Same, however, is not connected to the case record. Registry will trace out the said affidavit stated to have been filed by the state and connect it to the case record and list the matter again on 30.
My lord, if it can be on, my lord, 28.
28, all right, 28th.
File.
28th of January.
Obliged, my lord.
Please.
In the last occasion, your lordship was pleased to issue notice, my lord, and fix the matter today.
Lordship, I am yet to receive instruction. Pay for some time, Lordship. Let us come after 3 weeks, Lordship.
Mr. A.K. Barua for the petitioner, Mr. B. Chakraborty, learned CGC. For the respondent, Mr. B. Chakraborty submits that further time is required to complete his instructions. List again on matter be listed again after 3 weeks. 27th of February.
Obliged.
May it please your lordship. My lord, in this matter, I yet to receive the written instruction. The lordship may kindly grant me some time to file affidavit.
Mr. Sankam appears for the petitioner. MS MD Bora, State Counsel, appearing for the Transport Department. Prays for further time to complete instruction list. After 3 weeks.
My lord, obliged. Lord.
Yes.
Lordship, we had filed the affidavit in opposition yesterday.
Who filed?
Respondent number 6.
We have filed it.
Yesterday.
That's.
Hmm.
On the record, no? They have filed it.
It's not on the record yet.
Counsel for the petitioner, MS
Abhishruti Basu.
A. Basu. And Mr. N. Goswami, Learned State Counsel, submits that affidavit has been filed on behalf of respondent 6 yesterday, which however is not connected to the case records. The registry will trace out the said affidavit stated to be filed by the respondent 6 and connected to the case record. Mr. S. Bora
appears for respondent 4.
appears for respondent number 4 and submit that affidavit has already been filed. List again on 13th February.
May please your lordship. Lordship, can this matter be taken on some other day?
Might be listed again on 12th.
Yes, sir. Interim order.
Mr. K. Jain appears for the respondents. Interim orders, if any, will continue till the next date fixed.
Lordship, in this case, pursuant to your lordship's order dated 4/12/25, both the named arbitrator has given their consent marked as X and X1.
Yes.
So their consent has been received. So the matter may be closed by fixing a date when both of them will sit and appoint the presiding arbitrator.
Both of them have given.
Yes, X is the one, the claimant, the petitioner has Mr. M.K. Chaudhary, M.K. Bhattacharjee, and X1 is Mr. Ajay Chandra Vardhara.
Yes. Okay.
Your lordship's order was
While
on
order dated 4/12. When was it?
Your lordship had passed that order on 4/12.
4/12.
4/12.
All right.
Pursuant to that, both of them has.
Pursuant to the order dated 4/12/2025, Mr. M.K. Bhattacharya has been appointed, retired district judge has been appointed as the arbitrator on behalf of the petitioner.
That's right.
And Mr. Ajay Chandra Vardhara has been appointed as the arbitrator on behalf of the respondents. Stop. Both the arbitrators have given their written consent as required under Section 12(1), the Arbitration and Conciliation Act, and the same are kept in the, received and kept in the court case records and marked as X and X1 respectively. Stop. The written declarations have been perused and they have expressed no handicap or difficulty in acting as the arbitrators if appointed. Considering the same, the appointments made by order dated 4/12/2025 has been confirmed. Is confirmed. Both the arbitrators, the parties will now appear before the arbitrators. Both the arbitrators will respectively sit,
The forum has not yet been.
will sit and appoint a presiding arbitrator. Let the parties approach the arbitrators within
1 week, Your Lordship.
on 20
Yes.
or
Within 24th, we can only place the order before this
24th.
can be done, means just to.
The
intimate
orders, the parties will appear before the arbitrators for appointment of the presiding arbitrator on 24th of February. And place a copy of this order. List. Then we are closing it.
Yes, yes.
The petition accordingly stands closed in terms of the above.
Highly obliged.
Obliged.
Last item, item 3.
Lordship,
Huh?
this will maybe notice to
Huh?
the bank.
Huh?
The defeasing of the account, Your Lordship, by the cyber crime and without any giving a opportunity of notice.
No, but who's for the bank?
The UCO Bank, Your Lordship, Zalesar branch, UCO Bank.
Who's the counsel for the bank?
That Mohesh Sharma, perhaps.
You'll have to call him. He was here in the morning.
He is right now, maybe probably in the DRT.
So we'll keep it next week.
Date maybe fix it. Date maybe fix it.
Huh? We'll have it on 28th.
Lots.